Just a little one-lane highway. No why. Shannon, you're always the back of the bus.
Joanna sitting
That's her
Okay.
stuff, I'm not sure.
on your bill?
I know that's her stuff, I don't know where
Okay.
she's sitting at.
Whose stuff?
Yeah, Joanna.
She's in the kitchen. She's coming in.
I haven't keep that.
She wants me to.
I'm sure I can.
We're gonna go to the house Friday,
Okay, good,
8 AM.
good, good.
And,
The wizard's up there. Yeah.
Bill Bailey's flying.
Okay, that's the fastest I've ever eaten a salad.
Jillian told me it was something $8,000, but that's okay.
No, no, she went to my husband at the same time.
Whoa. What can you do? Can you go to the-
Correct. I mean, really, the homeowner's issue is recourse. Joanna, you wanna sit here?
I just put my stuff next to the different folders, because I had to go grab my soda. So the rest of the story is related with the $6,000 check.
Yeah,
No $6,000 check, but she did get a deferral of impact fees to $6,000.
okay,
That's what she owes, but they're like, we don't have any check. I know, I knew you
so
didn't.
the housing office,
Housing deferred it, but nobody has any checks.
okay.
Okay, good.
All right.
Scary crew back there.
That can't. Most of them.
Chazawitz?
Yeah.
It's a really nice place, you'll like it.
Really?
Yeah.
Oh, yeah.
I went paddleboarding there one time.
I gotta try
There,
that.
yeah, it's, crystal clear water, there's manatees, it's the whole thing, it's really,
Can you
really nice.
fish in there?
I'm sure you can, yeah.
Yeah, it looked good. And the count's good.
Laurie, I'm gonna give this.
Well, the county's on altitude with
I try to take the other
Yeah.
notes, I don't want it to get mixed up.
Thank you very much.
rules that I don't know.
Oh.
Yeah.
Oh, he's not in here either? No, I guess he's not in here. Okay. Well, let me go find out where Brandon is.
Your other person's not here, so slow down. You're making me gag watching you so fast, girl.
The time is 1 o'clock, and I believe that's when we had set case numbers 24-620 and 23-1028 for hearing. And I understand not everyone is, there we go, okay.
Some people.
All right, that's okay. I just brought us back into session, and so we're continuing the hearing that started at 9 o'clock today, but we have this specially set. Mr. Lon, oh, go ahead. If you need to talk, that's fine.
Sandy, that fruit punch anywhere in my face?
No.
No. It spilled all over, and as I was starting to drink it, I'm like, now I'm doing the clown lip sync.
Maybe 14. Oh, yeah.
Do you guys need more time to confer, or?
If I could just have a couple of minutes.
Yeah,
We just got some new information, I apologize about that.
Hey, that's fine. Do you want me to adjourn?
I don't think you can adjourn, I think you can have a break.
Have a recess.
I can
Recess.
do whatever I want, to be honest. But, you know, I have learned the lesson the hard way that really is not a good idea for me to tell judges what they can and can't do. I'm not a judge. But I do want to put on the record, I think I have met you, or at least one of you before. You're Hubbards?
Yes,
Do you have a sister,
older and younger.
Corey?
A lot of us, yes.
Okay. I don't think that's an issue. I think I've met you before in Orlando at some point.
Do you go to UCF?
No, but I knew your sister. Yeah, so I don't know who you are, to be honest. I know of you, so I don't. But I think I have to put on the record, just so you know. So you can move to disqualify me if you want. But that's all I know is that I've met Miss Hubbard before, many years ago. Okay. So what we'll do is we'll take a break. The time is 1:05. How much time do you need?
Probably 5 minutes.
All right, why don't we just come back at 1:15?
All right, thank you.
Thanks, sir.
Joanna?
Oh, and Risa was talking about, I didn't know if you should.
I'm joking.
Because I know that.
You've said worse to me.
Can't adjourn the board has.
No, I know.
So we get a little paranoid about that. Horrible.
we proceeding?
Yes, sir.
Oh, there.
Are we waiting for them?
Yeah.
Okay, that's fine.
They're kind of important.
I try to make it easier for you, it's a good thing.
I'm all for it. That's why I tried to allow a little extra time, but
Uh-huh.
lawyers.
So here's a
Can't
letter
live
from
with
Lenny
them, can
earlier.
you?
that
Oh, we
has
could,
$6,000
we could live
check.
without them, I think, but you
Says
know.
this is FYI, the letter that Housing Services sends out saying that you're qualifying.
So the reduced impact fee will be 59.
59 something, yeah.
Thank you.
So you put in a file if you want. We're not hold checks, but that's what she's saving money for. And she does it to pay 6,000. I don't know where the other comes from. I guess her permit fees is maybe because she's gonna have some permit fees.
I can put it on a USB if you need to.
I know.
I can go plug it.
Lori,
put
are
it on
you
a
gonna
USB
check
real quick.
on them, or?
I was gonna check.
I think someone should, or let me know how much longer they're gonna be.
I'll do that.
Okay, sorry.
Oh, you're fine. Lori, I got it, It's okay. That's for stuff for me instead of you.
I can, if I need to, I can go put it on the USB. real quick.
Okay, let me just see if.
Yeah.
Wasn't like permanent solution.
Mr. Christian, they said 30 seconds, you know, attorneys, I'd add a little bit on that,
Okay.
300 seconds.
Oh, it's moved over. Okay, thank you. Gotcha.
Are y'all gonna be displaying stuff during this hearing? Wow, okay.
Trying to. Some technical difficulties.
Okay, thank you.
One thing I would love is a projector. Some,
We have,
really? Something like that people, regardless of the party, could just put something on the projector and then it would be on a screen.
we have,
I think it's a good idea because sometimes the respondents bring stuff.
Right.
Right.
That was said one time, and she already set it up for us, got the equipment and everything, we just haven't used it yet. It's here,
we're getting there.
Okay.
very low tech, but it was a really good idea. See, I told you 30 seconds, 300 seconds.
What do you mean? Isn't that me? Oh, no, it's me.
Make sure I got everything.
Oh, it is? Oh, it is. Thank you. I think it did once when I was trying to find a case.
Oh, it says I'm connected. To the public, that's how you connect?
Yeah,
Or S, do S.
I can never get the best to work, so I always do.
I have S.
Because Kat in the office there, she can get the.
Okay. Wow, something to do. But this morning I connected.
Let me go beat him.
I'm gonna start the hearing, so.
All right.
All right, the time is now 1:18. This hearing is back in session. Do the parties have a resolution?
To one of the cases, we have a resolution.
Okay.
To the other, we would like to come to the special master to kind of get some direction.
That's fine. And it's not, the resolution on one of the cases is not contingent on the, it's like that's, you guys are agreed on.
Yes.
All right. who would want to announce the resolution or the case number? I don't know.
So we're actually talking first about the building case, which is 2024000620.
Got it.
Which is on page 17.
Yep.
My understanding on that one is the respondents were going to agree to the admission of the evidence and no contest on that one.
Yes, we're not gonna contest the permit aspect of it. We would ask that it go on the record of what specifically the permits are that are being alleged that we
I
need to
agree.
get.
I won't do it unless we do that.
Right, and that's what we will not contest that. We understand and we're working through that, and we'd ask for 90 days to be
Okay,
able to.
and the county has no objection to that?
Correct, and we, in speaking with the attorney, we understand some of what might have been done might be under agriculture, and so that might be just a separate form they have to fill out without needing an actual permit, but there is still a form they have to fill out with the county, and the attorney is,
I understand.
for farm buildings, correct?
Correct, okay. In other words, there's an exemption through the, okay. I think I understand that. Now, in order to put that order on the record, which I'm happy to do, there normally is a fine if it's not brought into compliance in the amount that's allowed, or in the time that's allowed.
Yes.
Have you agreed on that?
We did not, Mr. Norman, for
Is there a
the building
recommendation?
case, what's the recommended?
For the case ending in 0620, our recommendation was $1,000 a day.
And the building permits that they would need, permits or forms that they would need to complete deal with electrical, solar, adding buildings to the property, extensions to existing buildings, docks or decks that they have on the facility, on the property, re-roofing.
Just one second.
Hold
These are new ones to me.
Oh, no, they were part of.
Re-roofing?
Yeah, that one did just come up, sorry, that was on, that one just came up, that was on the barn. That's why I'm not sure if it would be a permit or just that form, because it's for the barn.
Understood.
I see what you're saying. So that's not one that you necessarily need a permit from Citrus County for, but once they get whatever they need, I'll wait for Mr. Wands. I want him to hear.
Just for clarification, and sorry, I know we thought we, can you guys indicate which you're talking about? So I can have my clients make sure they understand which one.
This one?
We put paint on this one. I don't think we've touched that one. This one over here we enclosed. Right there, we added that little into it.
Mr. Costa, have you been involved in these discussions?
No, not prior to today.
I just talked to discuss my clients. They said they've never put a new roof on that.
And again, if it's not a new roof, we just need to see that that's not, we just haven't had access. We can't look at it, we have to go off of evidence and photos that we have. So if it's not, then
Okay.
we just need proof, something to say that it
This is,
wasn't done.
I'm not admitting any of this as evidence, all right? This is for the purpose of resolving.
Yes.
But in order to understand, so it's the county's proceeding under the assumption that there is a roof that may need a permit or
Correct.
an agriculture exemption.
Correct. Because based on photographs that we have, they appear to be different.
Just so you can.
I mean, I'll show this to the county as well, but, so what are you giving me?
That's what I was presented
Yes.
by the county.
Oh, I
Their
see.
evidence, and they're stating that
I
this
see.
was a new roof, and actually what happened, I believe they painted these, but have never re-roofed any of these.
I understand.
So it's just a difference.
So you would be prepared if we actually proceeded at a hearing. It's not your intention on this case, but if you proceeded, you would proffer that that part of the roof was painted and it's not a new roof.
Correct. That's not a violation. Again, I'll take a moment to kind of put this out there. This is
I'd like to know.
Yeah.
Yeah.
This is a relatively long-running case where I think there's been a lot of misunderstandings and a lot of confusion. I got brought in probably November of last year. and ultimately there were attempts to try and resolve it. There was miscommunications that then put this on hold till about March. And then ultimately, since that point, we have been in open communication. My client is married to a foreign national who she goes over and stays in Spain with him, so she's just returning.
My wife is a Spanish citizen. I understand that, so yeah.
So going visiting family, just returning, so a lot of this has been kind of unfortunately prolonged as we've been trying to resolve it.
I understand.
But we're kind of in this place of trying to determine new law or establish how a Florida statute would apply to a local ordinance, which is.
And by Jove, I'm willing to do it. I
am sure you are, and I think all the parties would like to see if we can get it resolved with the county prior than you having to create.
I think that'd be great.
So I think.
Because who knows what I'll do? I don't.
So that's kind of where we're at. And to the code officer, Norman, I would apologize. I have been made aware that someone from our staff or our team was rude to you at points, and we apologize. I represent these folks. I've talked with them. They have said that they have tried to be as cordial with you as possible, other than getting a lawyer, which I know complicates things.
Well,
But
let's just talk about this resolution for a second, because I think that's all important. But before we get to that, you were putting on the record what your understanding was. We already hit a hiccup, which concerns me. Okay.
Two more things. Some of the buildings that we've discussed that need permits, I just want to make sure that things don't slip. If those buildings have air conditioners, obviously that needs a separate permit. If buildings were built but then enclosed, the enclosure portion does need a permit, but that's all building related to me. And that's it.
Here's my concern before entering that is I'm concerned that something in 90 days holds up the agricultural. That process, you have no control. The county has no control over that. You don't. So, if it was just a matter of working with Mr. Acosta to get a permit and everything, y'all have some control over that. You can expedite things. But if them needing a permit from Citrus County is dependent on whether or not something is exempt through the Florida statute, I have concerns that 90 days is insufficient time.
so to be clear, the one we are not contesting and asking for 90 days is strictly to the permits. We already are a bona fide agricultural grounds.
Oh.
It's the question, the statute we're referencing is Florida Statute 570-85, which deals with Florida agritourism and the ability for a bona fide agricultural site to be able to create new revenue streams by bringing people on for that. We are not, that is one question. That one I'm going to probably ask for a little bit more time to make sure we can get a resolution for usage. The question for the buildings is what we're looking for 90 days for, because my understanding is we can work pretty quickly with
I think
the
I
county.
understand. So you're going to ask me to continue the issue of the use?
We're not there yet. We're not there yet.
All right, please proceed. Yeah.
So just for the building portion.
Okay.
90 days, they need to get all the permits, and I think that's where we're at, and that would resolve that case.
Okay.
And I would ask $1,000 a day seemed kind of steep, because I am concerned there may be things that's such a broad swath of, hey, you need to get this done. That was like anything that may or may not be identified. I was hoping we get like specific, hey, this building, this, that.
But you're saying that when they go back on, or when they're allowed on the property to look at this, they may find other
Yeah, I want to
things.
make, yeah.
Well, if I limit the scope of the case to what's been brought before me, and let me talk to you about that.
Two things. If you do this and admit the evidence that we have to present, that evidence shows photographs of everything in terms of building, enclosure.
Right.
Some things are just a little corner because that's all they could get a photo of. And we did try to get aerials from the property appraisers, which I believe that's what you showed him with the aerial from the property appraiser. So that should encompass everything that, correct, Mr. Norman? I'm not misrepresenting anything. The photos show, for building purposes, what's in violation.
To the best of my knowledge. As
All right,
of
but
today.
what I'm not going to do is leave it open-ended if we have a resolution here. So to the extent that y'all do find something else, I'm not going to then say on day 89, when you're there to close it out, or whatever day it is, you find something new, I'm not gonna have that be a violation of the order I enter today. That's gonna be for you to pursue on a new case if you can't resolve it. Does that make sense?
Yes, sir.
That's what I'm gonna do.
That's
Okay,
fine.
all right.
As long as you're, Mr. Norman, do you have the exhibits for this,
I do.
the building portion?
I do.
If you're accepting those, then I think that would take care of everything unless there's more questions.
I'm accepting them. I'll take a look at them because I don't want to set anyone up for
And
failure.
that's just for the building? Okay.
In other words, Mr. Alonso, what I do is I don't, when I say I don't want to set someone up for failure, if I don't think it's going to take 90 days, I'm going to give more.
Appreciate that.
But you guys seem to have an understanding of how long it'll take. So
Correct.
let me just take a look at it.
Thank you.
If I could just explain to you,
Yeah.
Exhibit A will be photos that I've taken during the course of inspections. They're all dated. Exhibit B will be a copy of the notice of violation, notice of hearing, and the continuance order that you issued. Exhibit C, that's going to be the web captures that I took from the Citrus County Property Appraiser's website
Okay.
for aerial images. And on the very last page, you're going to see, it's going to be Exhibit D. It's just a picture of a guest map that I pulled from the farm's social media page. It's just a map that they posted, an illustrated map that they posted.
Did you
So-
put your demonstrative item on the back as well?
I think it did print onto the back of that one. I have the other copy of the demonstrative as well.
It's like a cartoon map.
It should be like the second or third to last page.
So this is going to be the northern part of the parcel. There's two structures there.
I want to make sure Mr. Alonso can hear what
Oh,
you're
yeah,
saying.
yeah.
So
Sorry.
So on the very last page is,
the last page of this whole thing.
yeah, because on this one it's printed out, the whole.
Oh, I see.
So, on the back of this one, that's the rest of the demonstrative.
This is a demonstrative.
Demonstrative only.
It's
so
not being admitted
It
into
is
evidence.
not being admitted into
Okay.
evidence. It was just for, and I believe that's the very last 2 pages of your package.
Got it.
Okay, then I'm gonna leave it out, okay? It's helpful for me to just look at and see what's going on.
Yeah, so then, on the demonstrative, I put on there, the names, and I also put a number to correlate with. So once you're looking at the actual pictures that I took, as well as the,
Is this a demonstrative?
that one is, yes. Mhm.
It's the other half of
It's
that,
the
right?
other half.
Okay,
It's the
okay.
northern part that I inspected.
I see, okay.
But on those exhibits, you'll see that I labeled the structures correlate with the demonstrative.
Okay, so I'm separating, Mr. Alonso, I'm separating 2 pages that are being represented to me as demonstratives and not evidence.
Understood.
All right, I'm admitting, is this exhibits A, B,
That's A through D.
C, and D?
D is actually, do you have it separate? Because it prints on the back of his. His D is printed on the back of your demonstrative.
I'm okay with excluding it if we
Okay.
need to. I don't think I have a copy where it didn't print on the back on accident, so.
I think we might just have to mark through the demonstrative and then we can put D in. Your Honor,
D
I
would have been
believe,
that guess map. I apologize.
yeah.
I don't know what exhibit D is. Okay, so you're stipulating to the admission of only this side of the page, Mr. Alonso. And what I'll represent, it appears, it's labeled as a guest map. Have you seen this?
Yes.
Okay, and you have no objection to it coming into evidence pursuant to the resolution the parties have come to?
Yes.
All right, is there any objection to me entering what I believe is the resolution?
My only question
Yeah, go ahead.
is, I know Mr. Alonso asked for a reduction in fine. I didn't know if you wanted any testimony as to why the fine was, we said
If
$1,000
the parties,
a
I would hear
case?
from both parties as to that. If they're willing to stipulate to me determining under my discretion what the amount is. In other words, you've agreed on everything else except for the fine amount, and you're gonna leave it up to me to determine, then I would wanna hear from both sides as to aggravating circumstances and mitigating circumstances. Does that make sense?
Absolutely.
Yes, sir.
All right, first I'll hear from the county.
Okay. So this case became, this case started due to the other case that I have today, the 2023-01028. During the course of my inspection, that's when I discovered that there were several structures that did not have a permanent history. Similar to my interactions with the persons in the property for my previous case, I was refused access to the property to make an on-site inspection. I was accompanied by Citrus County Aquatics Division to access the bordering waterway. That was the only way that I could actually do a semi-thorough inspection of the property due to the fact that I was refused access to the property. I was able to document several structures that were erected with no permit history on file. Several other structures and modifications were documented using aerial images found on the property appraiser's website. Based off the information that I found, I issued a notice of violation, and in all subsequent inspections, the structures remained with no activity towards compliance. At one inspection, while traversing the bordering waterway, we were approached by an individual in a golf cart, and they followed us as we traversed the waterway. One person on the back of the golf cart began to hurl
Slow
insults.
down.
Yes.
Breathe.
Oh, yeah, sorry. One person on the back of the golf cart began to hurl insults and attempted to intimidate the airboat operator and I with threatening gestures. In order to de-escalate the situation, we departed the waterway. I later met with an individual who identified himself as Mark Hubbard at the driveway of the property. We discussed the violation and what would need to be completed to abate both cases at their property. To my knowledge, the health department as well as the property appraiser's office has also been denied access to the property. Health department for on-site health and safety concerns, for septic issues and human waste disposal, and the property appraiser has been denied to assess the property appropriately.
So let me just ask you a question about you said the Department of Health?
Yes, sir, the Department of Health.
Is it the county or the state?
The state.
And how do you know? Have you reviewed records? Have you spoken with people?
I have spoken with.
They're here also.
Okay, yeah, perfect. We do have members from the health department who were denied, and they can speak on that if you'd like.
It's up to you. I mean, I'm not going to do your case
I
for
think
you.
it's. I
Did
think,
you speak to them?
I didn't speak to them directly. That's what I was informed to
Okay.
by our director.
I've spoken with them.
Okay. It's up to you to give me what evidence you want, so before I turn to Mr. Lonzo, and he has the right to cross-examine, by the way.
100%.
So who do you want to present on this?
I'd like to introduce.
Environmental health.
Yeah, representatives from environmental health that have interacted with the property.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please
Yes.
state your names.
Thomas Doherty, Environmental Specialist 2, Florida Department of Health in Citrus County.
Nicole Zarkowski, Environmental Supervisor, Florida Department of Health in Citrus County.
Okay, good afternoon to you both. What would you like to tell me about your experience, or that'd be relevant, I guess, for determining what the fine should be today?
So on, I believe it was October 31st of last year, both of us went to the property in order to perform an investigation after receiving a complaint. We were able to access just the front of the property where there were a few structures. We went around to look for somebody in charge, found a man who identified himself as the property manager. Can't recall his name right now, but he refused us access to the property. But I believe he did provide us a phone number, and I don't know what happened after that. But
And you
Yes.
both were together at that time?
We were,
Okay.
yes. So, yes, we were provided a number to the property owner, Tara. And I did make a phone call to her, explaining why we were on her property, to further discuss the complaint that we received. We ended that phone conversation with planning, getting ready to schedule to have a meeting to meet on site so we could, go and have access to the property to investigate what the complaint involved.
Okay, and is that it?
That's all I have.
Have you ever been back to the property since?
No.
Okay. I appreciate your testimony. Mr. Lonzo, before, I have no other questions for them. Do you have any questions?
Could you elaborate what the complaint was?
Yes, so the complaint that we received, it was an inter-office complaint from a code enforcement. And to my recollection, it involved unpermitted activity, involving septic systems and glamping sites, so tent sites.
So I want to make sure I understand your testimony. There was a concern within the county as to septic systems?
That's what the complaint, involved that we received, yes, to my recollection.
And that's why you went to the property?
That's why we went to the property, yes, because those are under our authority.
Okay.
Do you know what initiated the complaint, the inter-office complaint?
Yes.
What was that?
What do you mean by that?
What led code to send you that request?
I can't speculate, why they sent that to us. I can only make an assumption, but that's just because those items, like I mentioned, the glamping and the on-site sewage treatment disposal systems, the septic systems, those are under our authority.
Okay, so the basis
Regulatory
of that
authority.
complaint was you don't have any further basis other than you just received that from inter-office, correct?
Can you explain what do you mean by,
Sorry.
yeah?
There were no outside sources, or you weren't provided anything further than the inter-office request from code.
Correct.
Was there any supporting documentation that was sent to you at that time?
There was no other documentation to my recollection.
Okay.
Yes.
Thank you, I appreciate it.
Thank you, appreciate it.
All
I
right.
don't have any other questions for you. Mr. Norman, is there anything else that you want to share?
So through the course of all this, and once we get into the use violation portion, it really kind of delves into the fact that the mindset of the property owner seems to be very standoffish, uncooperative.
You're talking about
I'd object to that.
mindset, but I guess what I would ask is just your observations. If
Mhm.
that's your observation, I would say it's
that's
your
my observation. yes, sir.
observation, okay.
Mhm.
In other words, it's difficult to get in someone's head, per se. I have found it difficult, at any rate.
The same interaction that they've had where they spoke with Ms. Tara about setting up an appointment to come onto the property and do an on-site inspection. That's what I've heard from the other departments as well. The ball starts, but it never goes anywhere. So that's kind of where we're at.
Okay,
To this day, I've never been invited onto the property to complete a thorough inspection
until today.
until today.
Okay, I appreciate that. Is there anything else?
No, that's it.
Do you have cross-examination of Mr. Norman?
Do you recall what your response to the owners was when they told you that they got an attorney?
I said, I believe that my response would have been, I don't recall the exact words that I said, but my response would have been that, okay, well, I can no longer have contact with you. Attorneys have to have contact with each other.
Do you recall indicating to my clients that it was a mistake to get an attorney, that it complicated things?
No, I would never say that.
Any other cross-examination? All right, then,
I have one question.
Yeah, yeah.
Oh, sorry. Just to clarify, since we're dealing with the fine amount, when you're determining the fine amount, do you take into account how many violations are on the property?
Certainly, the severity of the violation, especially because this violation was observed through the course of a previous case, it definitely has a direct impact, especially with it being for buildings and stuff like that. I mean, who's to say that some of these buildings aren't sound? So the health and safety, until we get on site and can determine that these buildings are safe and these structures are safe, I do believe there's a health and safety concern.
No further questions.
you're concerned about the safety of the structures?
Certainly. There's a two-story gazebo that's sitting directly on the waterfront that's powered by solar. It has solar electricity going to it.
I'm just trying to understand.
no,
So
completely.
how would the solar affect the structure or the structural integrity?
Well, I'm saying there's electrical components on a two-story structure.
Okay, that makes sense. All
Mhm.
right. Any other cross on that point or questions? Mr. Alonso, do you want to present mitigating evidence?
I would say the mitigating evidence, again, I wanted to point out, I know that I've now been, it's on record that somebody from our facility was rude and lewd, and that's not okay, and we don't condone that. And my clients have asked one thing from the beginning, at least since I've been involved, which is clarity on what specifically is being argued, or what the specific violations were. It was not until we received the notice of violation that we were actually given specifics, and even as we just found today, specifics of things have been loose up until we just got to this point of saying what it is, now having the roof. So my clients have absolutely refused entrance because they haven't known what was going on, and we're not going to sign up for a fishing expedition. That being said, since I've been on board, we have been in communication. We've been trying to get this resolved. I've submitted multiple motions to you as we've been talking through it. The fact of $1,000 a day concerns me because my client, since your last order granting the motion from out of the country, was trying to work through and has bounced around and ping pong trying to get, where she needed to be able to have a pre-application appointment, which she does have for October 1st. And I think just the confusion of that process, along with the fact that I think that that's even for usage, which is probably not even what we're dealing with. So I'm asking for a little bit of a mitigating factor to know that there are, even in what was presented to us, the possibility that somebody could come in on day 89 and say, well, that was an enclosure we just talked about, and we had no idea. So I would actually invite the opportunity to be able to have the 90 days. We want them on. We want to get on compliance because this is something my client intends to do and wants to work with the county as much as I'm sure at the moment it doesn't feel like.
All right, so first, what I'm going to do is enter an order finding that there is a stipulation as to most of the order in case number 24-620, and that is that there is a violation, but 90 days is going to be granted in order to address electrical, solar, adding buildings, extensions to buildings, docks and decks. Is roofing a part of this?
At this point, it is for us. If they can show our people no new roof, because new wood versus old wood, you can see a difference.
Okay.
Then it becomes a non-issue for us, but until we have that.
I need to be sure you're stipulating to that point. If it's an old roof and it's just been painted, then fine.
Just one second.
Yeah.
Sorry, I gotta find that photo.
That's okay.
Here.
That actually was there before. That part is new. That, not this.
Can I get clarity from whomever I need to get clarity from on this? I don't know if it's the council or.
Well, it's up to the county. How do you want to do that part? I don't really care.
I think we have an understanding of where there may be a roof issue on it.
Okay.
Well, if you're good on the roof, then we're good on the roof.
But I want to make sure I know which roof we're talking about.
Yeah, please. Let's
So-
be sure. The longest hearing we ever had here in Citrus County was a similar case. I don't know if you remember, I don't know if you were here, Mr. Charlton, actually. I mean, because you weren't I don't know if you were you were the officer.
The zip lines?
Zip lines.
Yeah. It was a long.
It was a pandemic era case.
Yeah.
Good times.
I legitimately just tried to expand it with my fingers.
For those watching on YouTube, listen, sometimes it's just a Wild West, and we're trying to sort things out on the public behalf, so.
If we stipulate to roofing around this building, would that satisfy everybody? Okay. We'll stipulate to the
What page number is that?
roofing as to the building identified on page 71.
That's
Of,
the PowerPoint.
It's the PowerPoint. It's going to be page.
I can show you which page.
is
of the
it, what exhibit?
It's gonna be Exhibit A.
Exhibit A, that's all we need for the
Perfect.
record. Yeah. All right, so page 71 of Exhibit A.
It's not page 71 though,
Oh.
because he's looking at the PowerPoint presentation that we were gonna present. and
Is
that's
it in the
not-
exhibit?
Yes.
It's in the exhibit though.
Yes.
It's
Do I
in
have any
Exhibit A.
idea what number it is?
I
Because
can-
normally you number them and it's,
I,
can you show me and we'll just put it on the record? Even if it's not numbered, I'll.
Third to last page on exhibit C.
Oh, okay, it's in Exhibit C. Well, that's easy. Anything around that building? Or on that building?
right.
Mr. Lonzo, let me just, I gotta be clear. It's just, so, is it this photo you're referring to?
Can I approach?
The
Yeah.
next ones, I think.
Ah.
It's the same building, but
Same
it's
building.
different.
Let's compare.
I believe it's the same building.
Yeah.
Can I, Derek, can you confirm these are the same building?
Okay, all right. All right, terrific. So, Mr. Alonso, it's the roofing on this building that we're stipulating to will be subject to examination and getting a permit if necessary.
Yes.
Okay. So this is a property appraiser aerial dated November 15th, 2022. I think it's been represented that it's an east view. Okay, all right. And if the property is not brought into compliance as ordered within the 90 days, meaning obtaining a permit as necessary, I'm not going to do a $1,000 day fine, and here's why. If it was unrepentant and we proceeded through the hearing, I would agree that it would be necessary for the deterrent effect. But here, they are conceding. I have seen the motions from council. I totally understand what your testimony is. But what I'm going to do is I think $500 a day will be sufficient to enforce compliance on this. That's not a small amount of money. So I think that's it for that case.
Yes.
All right. So we're going to proceed to the next case. Are we calling it?
Yes.
All right.
Next case, Hubs Ranch and Grove LLC, 2023-1028. Code Officer Brandon Norman, page 17 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
And here's what I'm going to do. I'm going to read a little bit from my preliminary statement because I want you to hear it. I want your clients to hear it, to understand, to have the same that we do for everyone else.
Thank you.
Right? You're going to get bored and you won't want to hear my voice anymore, but here we go. All right, my name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy, which has already been remarked on, I might add. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over your hearing. What I'm going to tell you applies to this case, so please pay attention. When your case is called, which it has been, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call the case and I will allow the county to present its case first. You will then have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and make legal argument. I will ask whether or not you contest the violation. You do. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak. And if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must be civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must fix the violation by the date I give, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county has the right to foreclose on that lien or seek money judgment against you after the lien has been recorded for 3 months. I encourage you all to discuss your rights and remedies with your own legal counsel. If I do find that a violation has occurred, I will impose all costs required by county law. I incorporate these into my orders as standard provisions. You do have the right to appeal any order that I make today as provided by law. Okay? So now I think we're ready. So just to be clear, Mr. Alonso, I allow the county to present its case first. All right.
Do you want to, he has something he wants to put on the record as an option for your honor.
Oh.
I have no problem with him doing that before we start presenting.
Wonderful.
So as we have discussed, this is a relatively complex issue that deals with preemption and not a whole lot of direction from the actual legislature. I don't believe are going to contest any of the facts. It's the question of how they would be applied. And while we appreciate your position here, we feel like this is something that would probably be better figured out as we try to go through how the county would allow usage and start trying to determine that. So I guess my biggest question before we go into what would be I'm assuming a longer unnecessary hearing, is my client, I believe this will be going on the record, my client, through her agritourism business, has people come out and stay. They've hosted festivals, they've hosted educational events, all which are around the education.
On this property?
On this property, while operating under the Florida Agricultural or Agritourism statute and potentially being in violation of county. So
Unless it's preempted.
Unless it's preempted, which, again, we feel like there's a lot of questions still that can be answered, and if we work together, we can probably come up with a solution. My biggest concern is if we consent to the allegations made, say there's violation and we need to get to that place. My client's got bookings and pre-obligations that I'd like to be able to say they can get through while we try to figure out with the county to get to a resolution point, where I don't necessarily want to admit, hey, we know that for a fact this is in, we just know that based on their compliance we probably are, but it could be preempted. We'd like to figure that out together before we have a ruling here where all of a sudden you might come down and say, you know, for lack of a better term, damages or sentencing, that they all immediately have to stop. I would ask if it would be comfortable with all of the parties that if we could get an extension, and I know that the county is not going to necessarily agree because there's liability and concerns that come with that, but an understanding where if we consent to that, where we could have at least a wind down time while we work together, where if we can come to a resolution, great, about usage.
Are you asking me to continue the hearing?
I'm asking if I don't ask to have a continuance, is there any way that we can have a period of time to mitigate where we would not immediately have to cease bookings that we have that are for tonight, or for festivals, which...
Let's assume arguendo that I find a violation. Is the county going to ask for an immediate injunction or equitable relief from me that commands them to immediately stop? Or, as is customarily the case, would you be asking me to determine amount of time for them to comply before a fine begins? Does that make sense?
It does make sense, and I know it was talked about.
It has been talked about. We do have the health and safety concerns that were brought up tangentially in the first portion, so we cannot agree to anything. We would defer to Your Honor.
I guess the issue there, Mr. Alonso, based on what the county attorney's office is saying, is that normally in these hearings, I just shared this with you for your own benefit, fines are higher, penalties are tougher, and I very rarely use the maximum extent of my power.
Yeah.
Unless there's a health, safety, sanitary concern. Now, in the past, some examples of those cases have been where there's like an RV or something, and they're dumping human waste onto the ground, like,
right.
and I've got the photos, and that's a real, I mean, that's like a nuisance that can affect people's health.
Absolutely.
So I think, I mean, does the county, I understand the county's position on, let me set that aside. So you're saying that short of a continuance, in discussing the potential relief that I might award if there was a violation, your main concern is me trying to shut it down immediately.
My client's got 90 days of bookings through Airbnb right now where people are planning to come stay at a location, and a couple of educational events that are already in the works, one of which is large enough it needs a temporary permit, which I do believe was also the original complaint that this stems out of, was from an event where somebody complained, where we did have actually that permit.
You did have the permit, yeah.
So ultimately, I'm looking at county council. I have been informed we did have a permit, but if not, then I will defer to that.
It's honestly irrelevant to me.
Yeah.
I think that I can't really give you guidance on that point before the hearing, because in order to determine what the remedy is, I have to know facts about what's going on.
Understand. And I would stipulate, and apologies cut off, we have agreed that we could have health and everybody that's been wanting to come on, that we would have them come on before or within the time that they want to come in, so that we can continue doing what we need to do while it's in a safe and sanitary way, knowing that, I think somewhere in here there's going to be a restroom concern where we can have portalets come in. And
is the county aware of whether or not health has the ability to shut it down outside of my authority? They do not.
I'm not positive they do not. I'm telling you, I talked to them a lot about this one, and they couldn't access and they couldn't force. So you heard their testimony that they couldn't force entry, so they had no reason to shut it down. They'd have to have some
But you've just
evidence.
heard that they would, or seem to be allowed, they're gonna be allowed entry to
Right,
inspect.
and then they can look at it, and if there is a nuisance, yeah, they have some
They have the
abilities,
authority.
but they haven't been on there yet, so.
That may make it, right, well, that's just something important for me to know. I think we should just proceed with the hearing unless, because I didn't hear a motion to continue. I don't know that I'd grant it at this point anyways, just so that, I want to give you certainty.
Yeah,
And
absolutely.
as well as the county on how you proceed from here. Okay?
Okay.
So, Mr. Norman, please proceed.
Yes, sir. Brandon Norman, Citrus County Co-Compliance Officer. This is going to be for case 2024 00620, oh, I'm sorry, 2023-01028, land use for low-intensity coastal and lakes district CL and types of use, recreational use, a violation of Chapter 2, Section 2401 and Section 2500C of the Citrus County Land Development Code. The address is 1077 East Gobbler Drive, Floral City, Florida 34436. Property owner listed as Hubs Ranch and Grove LLC. I have good service via the continuance order that you issued, and I would like to authenticate the following documents for this case to be admitted. This was supposed to be, they're all kind of, all the exhibits are on the same PowerPoint, but they're all separate.
Yeah, I'm
as
not
well,
looking
so-
at A
Got it.
through the second set, which is
Track
A
it.
through D.
Track it.
You're going to be introducing A through E,
Mhm.
correct?
That's correct. yeah.
Okay.
So Exhibit A for 2023-01028 is going to be photos taken during the following inspections: January 4th, 2024, June 17th, 2024, and September 17th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the continuance order. Exhibit C is going to be web captures from Wonderfield, www.wonderfieldfarm.com, and captures from Wonderfield Farm and Retreats Instagram profile, as well as tag posts.
Mr. Norman, I just would ask you to probably go just a little bit slower.
I apologize.
More for
Try.
my benefit,
I
'cause
try, yeah.
I take notes.
Yes, sir.
Yeah.
Okay, I'll slow it down for you. Exhibit D is going to be video captures from the Wonderfield Farm and Retreats Instagram profile that I found. And Exhibit E will be a copy of paperwork submitted at a pre-application meeting by Mark and Tara Hubbard for a conditional use permit for the property, 1077 East Gobbler Drive. You also have the demonstrative document for the map from previous. So this is going to be for Exhibit A.
Has opposing counsel reviewed these?
I was given them as I walked in
All
for
right.
this hearing, so.
If you don't mind, I think before I start looking at all of them,
I have printouts of the actual exhibits, though, that you can look at.
Is that what? was
whatever's
presented?
easiest for you,
This is
Mr.
what I'd like
Alonso.
to submit.
Okay, so let's talk about Exhibit A first. Mr. Alonso, I'd like to ask you to look through these and let me know if you have objection to them being evidence in this hearing.
And they should be the same thing as what's in the PowerPoint, just formatted differently, so
Okay.
they could all fit.
So that's exhibit
This is A? All
right
right,
there.
I'm gonna start with A. No objection to A.
Okay, Exhibit A is admitted as evidence. Exhibit B is a copy of the notice of violation, notice of hearing, et cetera, et cetera. Have you been able to review those documents?
Yes, no objection to B.
Exhibit B is admitted as evidence. Now, you can handle it in whatever order you want, Mr. Norman. I was just trying to go through these.
Completely understand, this is all new, so.
Okay. Have you had a chance to review Exhibit C, the proposed web captures? Okay.
And then B is on a flash drive because it is a video, so I'll have the flash drive to.
Okay. D is an IG account, correct?
It's a web capture as well.
Okay. Yeah, we need that AC. I don't know if it went off for a little bit or, okay.
Oh, yeah, D is the flash drive, I apologize. It's from an Instagram account, though, yeah.
Okay, so you're saying they're videos on an IG account?
Yeah, because it's kind of hard to print off a video, so we got a flash drive for you. And so that they can review it prior to, I can also, they can view it here if they like.
Anything you can do to expedite that would be great.
100%.
On exhibit, what am I looking at, C? Starting on page that looks like this, I don't have a number, where it says at the top, reboot and regenerate. I just want to make clarity that it's not actually from Wonderfield's website. That is.
And what is this page?
I believe it's talking about a retreat that was to be held, but it was through a nonprofit that was hosting it, that is a nonprofit that deals with.
It's on someone else's website.
Correct. I just want to make sure it's clear it's not.
That's not true at all.
Okay. Does it matter? I mean, do you object to the content or me seeing it?
I don't object to the content or you seeing it. I object to the
indication of the source.
That it was there, the source of it.
Then I will allow cross-examination and testimony as to the source. Okay. And I don't need to make a finding about that. I'll conditionally admit that page. Everything else that you don't object to, I'll just admit.
And then the last question is, are the last 7 pages all the same, or is there something different between what I'm looking at?
No, that was an accident.
Okay, just wanted to make sure I
They're all
wasn't
the
missing.
same?
Yeah.
Pull off the extra 6.
You got it.
Okay, everything else is stipulated in the evidence. 1 page is conditionally admitted.
Sorry, I believe there's 4 pages after that that we're all talking about that same.
Oh, I see. So there's 4 pages of the exhibit that you believe you're not making a substantive objection to. You're making an objection as to the representation of the origin.
Correct. It's 6 total pages from reboot, regeneration.
All right. They're conditionally admitted. Everything else is admitted. Thank you. And have you been able to get oh, he's got it, I think. Okay.
I can show him Exhibit D whenever he's ready.
Do you have Exhibit D, Mr. Alonzo?
I believe this is what I'm looking at right now.
Okay.
No, Exhibit D is the video.
Oh,
That's the one we have on the flash drive, but I can show
this
you.
E?
That's
Yes, that's E.
Yeah, that's
Okay,
Exhibit
sorry.
D,
Yeah, I've not seen D.
It's being represented as videos from an IG account.
it's from Instagram, but it's people sharing it that have created other promotional videos that have been shared to our Instagram. And some of the shots that are within that, the videos on there are from other locations.
You're saying that the videos were created by others, not your clients. They've been shared on the Wonderfield Farm and Retreats IG page.
Correct. They've
Okay.
been tagged and
All
done.
right. I mean, do
And
you
to
have
make-
any objection to them being evidence, regardless of the source?
As long as we understand that some of the shots that are within it are not actually on Wonderfield. They're promotional, you know,
Okay, so there may be things admitted here that are not on the property.
correct.
Do you think that's a misrepresentation?
I don't think it's a misrepresentation, but I do think it's relative still.
That's fine. All right, so it's admitted with that understanding. All right, next we're going to talk about Exhibit E. And Mr. Lonzo, have you had a chance to review Exhibit E?
1 second.
Yep. I lost the cap on that thing, so someone will have to find that later.
Different, totally different property.
Exhibit E, we'd object to. The objection is that this has to do with a different property than what's being discussed right now. This, I don't know relevance or why this would be
Okay.
brought in, but it's not
What's the
actually-
relevance?
The relevance has to do with the letter that outlines their plan for what they intend to do. The property they're referencing to is an adjacent property, that there's no physical border between it.
So it's your representation that this letter is relevant because what they write about in this actually would apply for the use on the property in question?
Certainly.
Okay.
As to the point of the fact that my client's doing agritourism, I can agree that this can be admitted, but as to any of the substance of the parcel or really what was happening, this is from 2020, February of 2020, as an application where my clients were trying to get a campground.
I guess my, part of this is, I understand what you're saying. We're trying to prejudge the exhibits, and I don't know what the county's gonna say about it. So what I'm gonna do is I'm going to reserve ruling on it and let the county present it in its
Yeah.
due course, if
Absolutely.
that makes sense. So its relevance may be determined later. Now, of course, you know that the standard for admitting evidence is a little lower in these types of hearings.
Absolutely.
Okay.
Also, I will, apparently there's a fence between the
Okay.
borders, so.
And I'll let y'all talk
Yeah.
about it in the hearing. All right, you can hold on to it. I'm not gonna admit it quite yet. And I'll let you proceed. So, I mean, you have the benefit now of A, B, C, and D being admitted. You won't need to deal with that process anymore.
Understood. So I'll just go into the narrative of kind of how this
Yeah.
all occurred. When I attempted to inspect the property in October of 2024, I received a complaint for.
October of 2023?
Yeah, October of 2023, I apologize, misspoke. After receiving a complaint for the property, there was a music festival that had occurred. I interviewed a few of the neighbors in the area and learned that this was not the first event that had occurred on the property. I interviewed approximately 4 different neighbors, and all their stories seemed to align with multiple events that are taking place in the property and create a substantial impact on the quality of life of the surrounding neighborhood.
Breathe. Brandon, slow down. You need to breathe
Oh.
in here.
Sorry. I approached the property and identified myself to someone passing by inside the fence line. I asked for some basic identifying information, and he was reluctant, but he stated he tended to the property and was also the security representative for the property. I explained my reasoning for the visit, and I explained that I asked if I could enter the property to complete an initial inspection. I was denied by the person. I asked if he had any contact information for the actual property owner, and he gave me the contact information for Tara Hubbard, who he had stated was his boss and one of the owners of the property. I then contacted Ms. Hubbard and explained to her who I was and the basis for my call, and attempted to set up a date to inspect the property with her. She seemed receptive at the time and tried to state that there was an event coordinator that had applied for a permit for the events, to which I replied there was nothing in our records indicating that anyone applied for anything. We scheduled an inspection and a follow-up call for a future date, and before I could complete the inspection, or before we could get to that inspection, I was informed that they had retained counsel. After that, I requested assistance from the Citrus County Aquatics Division to access the bordering waterway so that I could inspect the property. And on January 4th, 2024, I inspected the property and observed and documented 4 different camping sites, 2 of which had signage identifying them as Citrus Tent and Dragonfly Tent. After completing my inspection, I compared my photos to evidence I gathered from www.wonderfield.com that lists its address as 10777 East Gobbler Drive, Floral City, Florida. Patrons can rent these tents via Airbnb and VRBO. I then discovered that website allows third parties to rent the property and host their own events, whether it be private or public, and offers options such as acquiring vendors, supplying catering, and lodging for these events. I then documented information from their website about their own events, including the event that initiated my case, which was Wonderfest. Along with this event, they did not have any relation to, along with this event that did not have any relation that I could find to any agriculture activity, I discovered several other events that were planned that I believe would be a violation of what's allowed for the CLMH zoning of that property. As of September 17th, 2024, events that would be in violation of the ordinance have continued to occur and are planned to occur in the future, and the campsites remain available to rent. It's important to note that Mark and Tara Hubbard attended a pre-application meeting with the Land Development Division on February 24th, 2020, as shown in Exhibit E. And they supplied a letter at that meeting outlining everything they had planned for the property at the time that they listed, which on the form it says 1077 East Gobbler Drive. Their proposed title for it was for a retreat and event venue. No action has occurred since that hearing, and the property owners moved forward with their plans of turning the property into their proposed retreat and event venue. I have been informed that employees from the health department, like I stated earlier, and the property appraiser's office have attempted to access the property so they can do health inspections as well as, or septic inspections, as well as assess the property's value, but have been denied access to inspect that property.
I'd like to raise an objection as to bringing in Exhibit E as to separate property and separate lot that was put in there.
I don't, are you attempting to admit Exhibit E again?
I think I should, based off of the information that's on the pre-application meeting.
Let me take a look at it.
Certainly.
Brandon, you gonna hand him Exhibit E?
Yeah.
That'd be fine, yeah. Thank you.
I know. I tried to put it on the PowerPoint, but it wouldn't go there.
So what are you using Exhibit E for?
To show that they proposed a retreat and event venue for that property, and they were explained on what process they needed to do, and they failed to do that, and then went ahead and did the things anyway.
I'd object to that. Their denial was based off of the fact that that parcel is not marked as agritourism, and so that was the reasoning that they withdrew from that. And without the context of the entire, docket of that, it'd be difficult to be able to use it in that simple context.
I mean, it does say the site address is 10777 East Gobbler Drive, but
It's the entrance to get in, and the parcel is separate. Parcel
I know,
specifically
but it does
listed.
have the same address, and it does have the name Wonderfield Farm. And I'm looking at the other exhibits, and I mean, honestly, I don't know exactly, it does have the same, I'm gonna admit it, over objection, you've laid the record. So, go ahead.
So in the course of this inspection, right, it was discovered that there was human composting taking place on the site, which that's going to be addressed for us, for the county side, on the building permit side, due to the concrete slab and stuff that was put there. But our concern also comes from the fact that by hosting these events there, they only have, to our knowledge, one septic system that's for a residential address, not a septic system that could entail the amount of people that attend these events, which they've already explained that they have a venue that can hold about 200 people. I don't believe there's a residential septic system.
What's the size of the property?
The approximate size is, it's 31 and a half acres.
Oh, okay.
The portion that we're talking
Can you
about.
start with the beginning of your PowerPoint while you're going through all this?
Certainly. So at my inspection, like I said, I did on January, June, and then September. The only use violations that I could observe at the time were the glamping sites. It's just not allowed for their zoning that they have. So those are the photos that I documented. There's 4 separate glamping sites. On their website, they're identified. This one's Citrus Tent. The one adjacent to it is the Dragonfly Tent. These 2 don't have signage, but there's 2 more tents that are online that do have names, so I'd have to say it was those. I haven't seen any other tents that look like that on the property. When we get into Exhibit C.
Actually, before you go there, let me
Certainly.
just take a moment to look at Exhibit B so that I can see what's on it.
Certainly.
And I'll just take a moment, sorry. Let's talk for just a moment about the notice of violation.
Certainly.
So there are 2 code sections cited, Section 2401 and Section 2500C. So 2401, can you direct me specifically where I should look in 2401?
It's pages, hold on, my page is stuck. I have a printed out copy if you would like one. It starts on page 5,
Mhm.
so 4-5.
Yep.
And then it proceeds through 2-8, and 2-8 is where you have the
Table.
table listed,
Okay, so where in the table am I looking?
the whole table. These are the only things that are permitted, so anything outside of this table is not permitted.
All right, is it the county's case that none of the things that are subject to this hearing are conditional? Is it just that they're neither conditional nor permitted?
They're neither conditional nor permitted.
Okay, so they're just flat out, under the county's case, flat out not allowed in this zoning. Let me just take a look at it. Okay, I'm now looking, actually, before I get to 2500, let me ask this. What zoning in Citrus County does allow glamping?
For that, I have to refer to my expert witness, Joanna Katoon.
For example, Coastal Lakes Commercial allows event venue with lodging. There's a few others, I think rec event venues. Some land use districts, it's a specific use listed. There's event venue and event venue with lodging. There's two different listings that could be
That's what I
here.
want to see. I want to see an example of what it would
Right.
say in the code where it is allowed.
Go to Coastal Lakes Commercial or CLC, it's a little past the CO.
I need numbers.
I'm sorry, I don't have it, I don't have my.
Coastal and Lakes Residential, CLR,
Try to
so it's
see-
past that.
Past that, right. I'm sorry, Kimberly, do you have a page number?
Central Ridge Residential,
I'm getting it, please.
medium, blah, blah,
That
blah.
was not one of the things I printed, please.
No, me neither.
Okay, Coastal and Lakes Commercial District,
Right.
2410.
You'll see
And-
event venue with lodging.
I see. Event venue with lodging, only, the way I read this is it would only be allowed with a PUD?
Correct.
Okay, now I'd like to go to 2500. I think I understand what the county is saying. And the only reason I want to see it is I want to understand why it's also cited. Okay, so this section contains a list of allowable uses within each land use district. Specific uses are either permitted subject to the minimum requirements, allowable subject to PUD, or prohibited as incompatible with the intent and character of the district. Subsection C is cited. Recreational uses. These uses include areas for outdoor rec activities such as picnicking, jogging, cycling, arboretums. Why is this section cited?
Because on CLMH, there's a portion on that table that says recreational use, so I just wanted to provide a point where they could go to and see what the definition of that recreational use for that property would be for. And the
Okay,
things that we're,
let me make sure I understand what you're saying. So you're saying that to the extent a recreational use is allowed on the property, it would only be the recreational use that's stated here?
it's not allowed.
Oh, it's not allowed.
You have to, I believe it's a conditional, you have to look at the table, I believe it's a conditional use.
All right. So you're saying to the extent that it would be allowed,
If
it would,
it
number
was-
one, be a conditional.
Those activities that would be listed, but the activities that we're
But hold on.
referencing.
Number one, that it would be a conditional use.
Mhm.
And to the extent it is allowed as a conditional use, it would be defined here in 2500C.
That's affirmative.
And it's the county's position that the uses on the property as we sit here today are not even permitted as a conditional use under this definition of recreational use.
That's correct, yeah.
Okay. I now understand Exhibit B, and you're walking me through Exhibit C.
Okay. So Exhibit C is where I did my investigation through online sources. This screenshot was taken from wonderfieldfarm.com. This just talks about the glamping village that they have that's on the waterfront. Here we see the four different tents. We have the butterfly tent, magnolia tent, dragonfly tent, and
Now,
citrus
you
tent.
told me that it's 35.1 acres, but here it says it's 66 acres.
I can't control what they put on their
No,
website.
I know
can
you
only go
can't.
off of what the property.
Do you know
appraiser
how big the neighboring property is?
is. I don't have it in front of me, but I could probably get it, just because we're not here for that
I'm just
property
curious
today.
if they're talking
When-
about both.
I'd have to
I don't
assume
know.
that they're including the adjoining
They'll have an
parcel.
opportunity to present. I guess I just want to know what you know, so
Yeah.
that's fine. Okay.
Because on their guest map, it does include that parcel that is adjacent to them.
Okay.
So this is just screenshots again from their website for the butterfly tent and magnolia tent. These were taken last week, and it still shows that through September they can still be rented. Same thing for dragonfly tent and citrus tent, also on here. You can see that it has dimensions and stuff as well. This was taken from their Instagram page. This is just more stuff that just shows that the use at that property is more than just residential, what they're doing right now. This was taken from their website, Wonderfield.com or WonderfieldFarm.com. This is the barn that adjoins the farmhouse. It has been converted into an event space that can, it says on there, you can accommodate up to 200 people. As far as I know, that's never been inspected by any fire marshal or anyone of that sort to be approved for that amount either, as well as we have updated electrical outlets and stuff in there too. This is also off of their website. This is For any one of the public, they can go on there and they can put in their information about what they want to host, what type of event they want to host. Here we have on here whether or not they need vendors, if they're bringing their own, if they're not sure, if they want an on-site concierge service, the whole shebang. This was pulled off of their website as well. This is one of their events. This is the Wonderfest 2023. This is what started the entire complaint.
Can
that
you
came
scroll
to us.
back to the
I
last
certainly
one?
can, yeah.
And you're saying this is on the Wonderfield website?
This is on, yes, sir, www.wonderfieldfarm.com. In the description of it, I can't find anything that would relate to an agricultural event on like agricultural use for farm use. So.
Okay, all right.
Again, this was from their Instagram. This is just one of their posts. It dictates the date and stuff for Wonderfest 2023, talking about it being a wellness and musical camping experience. Nothing agritourism there related. Another post from their Instagram page. This one.
You say nothing agritourism related, but I do keep seeing agritourism as a hashtag.
And that's.
But let me ask you this. How do you know it's not agritourism related? What is agritourism in the county's view?
So the definition for agritourism activity is any activity related to bona fide farm use, whether it be ranching, like tree work, forestry work, and I believe the county
Like
attorney's
going
office
and
has the
petting
actual definition for me as well.
Going and petting a pony or helping? No, I'm asking seriously. I love ponies. Are you saying, helping take onions out of the? What is agritourism?
So there are some things that they do that I do believe would fall under agritourism. I'm not presenting any of those events today. My presentation is on the events that have nothing to do with agritourism.
That you don't think are agritourism?
Affirmative.
Do you have a definition?
I do. It's actually defined by statute, if I may approach.
Sure.
And I have a copy for.
Got it up right now. I was ready to read it to you.
Yeah, if you don't mind, I'll just take a second to review this.
Certainly.
Do you have 57085 for him as well, so we can read it?
I do have
I would love to
57085.
have that, yeah. But let me read this first.
Would you like a copy as well, Mr. Alonso?
Am I still talking?
Say that again.
Do you need a copy as well?
Am I still talking?
I've got that one too.
Okay.
Good. Thank you, though.
I don't need to. It's just,
I do. Okay. Since I'll wait for Mr. Alonso to get done.
Sorry.
Since we're handing things out, I have 87 and 88 as well, and an OAG opinion on this as well, if you'd like me to
Ooh,
just.
I'd love that.
Everybody, everything?
Yeah,
Okay.
I want it all.
Please hold while I.
Again, this is all very new and.
We've actually dealt with similar issues here, so,
All right, this was 87 for him.
no, I don't think so. No one leaves here, or as the warden said in Shawshank Redemption, nothing stops. Okay, so.
Well, the hearing doesn't have to stop, but.
What is it in front of it's at the courthouse? What
It's-
judge?
Spate.
Oh, okay, give him my regards.
Okay, and this is the OAG opinion. Okay. We have 85, you already have 86, there's 87 and 88. Ooh, sorry. And then there's no OAG opinion.
Jennifer Ray, wow, okay. We got the heavy hitters here. Yeah, let me take a moment just to review this. That'll help me probably understand everything.
Mm-hmm.
right, so I read the AGO to mean that one cannot necessarily rely exclusively on the property appraiser classification of agricultural, whether property is agricultural or not, or used for agricultural purposes, as to whether or not it satisfies the exemption under 570.85 through 570.88, correct?
Correct.
Okay, I agree with that. So I think we're good. I've read all the statutes. Now, Mr. Alonso, I'll just say, we have had a few cases that asked us to apply similar statutes. I don't know if it was this exact statute, but it was the Right to Farm Act, that's right. So one of the issues with the Right to Farm Act, I say this, to let you know where my head is already at and how I interpret these things, is that one of the real relevant parts of this statute is the extent to which there's a bona fide farm.
Mm-hmm.
Okay, please proceed.
So this is a screenshot from their Instagram. Again, I couldn't find anything of agricultural relevance to farm use in there. So
is it the county's position that an agritourism business only can have things related to agriculture if it otherwise is exempt under the statute? In other words, let's say that 95% of the activities satisfy the statute in terms of you have a bona fide farm. These are things that are, reading from 570.86 subsection 1, and people view or enjoy activities including farming, ranching, historical, cultural, civic, harvest your own activities and attractions. They go pick the blueberries, if that's 95% of the use, but there's 5% that is a music festival, where there's no blueberries being picked, there's nothing else agritourism, does that mean that it's they're in violation of the code?
for those 5% of activities, that would be a violation.
Okay. I just want to understand the county's position. Okay.
So this is where I started with the Regenerate RX clinical retreat, where I obtained it from their website. I do recognize now as I did misspoke or misspeak. So it does take you to an external link from where my screenshot got, but it originated from their website on their public events page. And then that takes you to what Mr. Alonso was reviewing as far as the substance of it.
So are you indicating that the point he was making was correct?
Yeah.
Okay.
Yeah, it was. So I take that. But my original finding from it came from their website under the public events portion of their page.
Okay.
It took me here where, again, we're talking about a clinical retreat where individuals come and they volunteer for this clinical portion of it. Here we got a 2-night stay, single or double occupancy. It doesn't specify if it's in the glamping tits or if it's in some other residential farmhouse that they have. They're providing food, gift bags, wellness massages, curating programs. Again, there's just no agritourism activity that I can find on any of the things that are related to this event. Who can join this retreat says that they have to be 18 years or older because it is a clinical research. Again, I just can't find the agritourism portion of it.
Objection to that clinical research?
I mean, I think you have the ability to cross-examine, and that's really what your role will have to be. Yeah.
Thank you.
So the next slide just explains to you how the research process works. And then we move on to the Florida permaculture convergence. And this is where I believe a lot of things get kind of tricky in here, because while I do believe portions of this event do relate to agritourism, I don't believe that the camping on site, that amount of people, would allow that though.
Let me just see this. All right, so this is a photo you're representing to me. It's on IG, and it appears to be dated December 22nd. It was at least uploaded on December 22nd, 2023.
That's
correct?
affirmative, yes, sir.
All right, let me just look at this real quick. Is it your understanding that this is the only property in this photo is 10777 East Gobbler Drive.
So I can explain to you, so essentially this road is what borders the property line that runs right along there. This is the main entrance. That's where I initially started my entire inspection at. That's why I was turned away. This is the waterway that runs along to it. So essentially this portion here, and then the roadway up, and then kind of following that tree line where that waterway kind of winds through, that's the parcel. That's 1077 East Goblin.
So the upper part, what is the upper property?
Are you talking about this over here?
Yeah.
So that's actually a forest preserve or a nature preserve.
Is that county, state? Do you know?
I don't have the property owner's information. I just know that it's a
Okay,
nature preserve
just
on
curious.
that side. Yeah.
All right. Please proceed.
Yep. Here we have a screenshot from, this was shared to their Instagram page. That's how I obtained it from there. This just shows that we're doing yoga inside of the converted barn. And then we kind of move on to Exhibit D. These are a couple of videos that I've taken, screenshots or screen recordings of from their actual website. Let's see if that works. There we go.
Okay.
So that's just a recap video from Wonderfest, the event that sparked my initial complaint.
Okay.
Moving on, got the initial picture of a goat, right? But then we've got a festival, which I don't see how it relates to the bona fide farm use at
Okay.
all. Moving on, we've got another video. This one was Camp Sacred City. This took place this year, March 28th through the 31st. This is what Mr. Alonso was referencing to as far as some of these clips not necessarily being an accurate depiction of the property. The point of this one is to show that, I mean, these are all musicians that are playing at a residential property for an event that has, from what I can find, no agritourism relationship whatsoever.
Can you scroll up to the top?
I can't. Unfortunately, it's a recording.
Oh, it's
Yeah.
a recording. I see.
Yeah, I can pause it when we get to the top, maybe.
Okay.
Maybe I can't pause it. I apologize. Okay.
I do have some concerns about the music that might be played at these things. It
That's
doesn't seem like
the biggest-
no, it doesn't seem like it's a lot of George Strait.
And this is just another video. This one's
You don't regulate
referencing.
that. Okay.
This one's referencing Camp Sacred City. Again, March 28th to the 31st. But yeah, just more promotional stuff. But I mean, trying to link it to agritourism, like I looked for reasons to agree with. Like I agree with parts of the permaculture event that took place. I agree that some of those parts do fall under the agritourism exemption, but other events I just can't seem to find. That was supposed to be the video.
What was that last one? Okay.
Yeah, it was supposed to be just another little recap of Camp Sacred City, just showing kind of the stuff that took place. I mean, we have. Can you hit play on that one, Lori? I mean, it won't let me hit play on this one. This is just scrolling through some static photos. If you roll over the video, yeah, if you roll over the video, it'll bring up the play button. Roll over the picture.
Oh.
There you go. The play button right there at the bottom. So, I mean, we've got light displays. I mean, and some of these things are pretty disruptive to some of the neighbors, they've said, so. Like there, that's an entire, like that green is like a laser beam type thing, so.
Okay.
And then the last exhibit I have is Exhibit E, and that's just kind of referencing again what the intention was in 2020 to happen out there, and kind of how we're doing it now, without the appropriate measures that the Land Development Division asked of them. I mean, we were talking visibility triangle biological surveys that need to take place, parking infrastructure that needs to take place, lots of things that need to happen before events like these can happen.
I'm actually looking at your Exhibit E. Exhibit E says, past and current farm operation. Wonderfield Farm and Grove is a bona fide commercial grove and cow-to-calf farm. Permaculture design team from Florida, 14 acres of active pasture land, 6 cows in a bull, and goal to maintain 18 total cows, 4 acres of active citrus, 75 new plantings in 2019, food forest development for our guests, 28 acres of farm. In 2019, we purchased cattle, citrus trees from a local nursery, irrigation, acres. You've admitted this in evidence. Do you have any reason to believe these things aren't true?
That we have been provided zero proof of a bona fide farm operation taking place at Wonderfield Farm.
Okay. Do you have any other witnesses, or are you done? Or actually, if you're done, then I'll allow Mr. Lonzo to cross-examine.
Certainly.
You're
I'm
ready?
finished. That's the.
Mr. Lonzo, your witness.
Starting at Exhibit E, you had mentioned that they're the same plot to you.
I went off of the address that was listed on Exhibit E.
Did you look into the plot that was
I did not look
actually
into
listed?
the plot, no.
Okay. Would you be surprised to be aware that that plot actually isn't agricultural and it was a side plot that they were looking to do something? It's a separate plot where they were looking to be able to create land for people to stay, to be able to experience agriculture.
The question is, would you be surprised if that was the case?
I'm not sure how to would change anything.
What's your answer?
I went off of the address that was on the application. Mistakes do get made, so how do I know that that wasn't the wrong plot number that was put on the application?
When you guys are looking at things, do you look at the address of the plot?
We look at both.
Okay. If something plot-wise is separate than an address, would that matter if one plot was designated something while another plot was designated something else?
Certainly would matter.
Okay. You made the statement, neighbors weren't happy about it. Do you have any statements from the neighbors?
Just from my interviews with them, I mean, I don't have physical statements, or none of them wanted to. I even asked some of them to come today, and they wanted no part of it.
So no neighbors wanted to come forward to testify about the complaints you're saying were allegedly happening?
That I believe,
Okay.
that I spoke to.
And you don't have any written statements that were approved by any of them? So nothing to submit to evidence that neighbors were feeling disruptive other than your testimony?
The complaint. We have the complaint form that says that they were being disruptive.
Has that been admitted into evidence?
It's part of the case file, but it hasn't been
We
admitted
No,
into
it
evidence
hasn't
today.
been
No.
admitted into evidence.
We've just fielded phone calls in our office about it.
Well, the question was to you, Mr. Norman,
Certainly.
and I think you've answered it.
To the point of the complaint, it's part of the case file you said, but that has not been, and you don't intend to admit that into evidence?
It's part of public record, but it's not something that we use for evidence.
Okay. Have you had any further complaints that you're aware of since the original one?
I have.
Okay,
We've
have you
received numerous phone calls to our office.
Do you have any proof of that or evidence to that?
No, because we have an active case for it right now.
Okay. Would you document that within your active case?
We would make a log notes.
Okay. Are those being submitted for evidence right now?
Not at this time. No.
You made a few comments about, I don't believe that that's agritourism throughout that. Are you an expert in agritourism?
I've been counseled by the county attorney's office on the definition, so I'd have to refer to them.
Okay.
Being the expert.
When you were saying that, were you saying that as a fact or as an opinion?
That was based off of what I've inspected. Based off the definition that's been provided to me, I was unable to locate anything that would correlate to that definition.
I'll re-ask the question. Was that your opinion or was that a statement of fact based off of?
Statement of fact based off my understanding of the definition.
Okay. Do you have the expertise to be able to make that choice?
As a code compliance officer, I think I have some expertise in understanding and reading statutes. I do.
And that was something you got counseled by, I don't want to know specifics, but you said you were not aware of anything, how to define that until you talked to counsel?
No, I did my own research and I found the definition.
And you have no reason to believe that there's no agricultural, or that there's agricultural events and teachings and learnings going on?
That's not what I stated. As I stated before, I believe that some events do fall under the agritourism, but the events that I've presented today, they don't fall under the exemption for agritourism.
Okay, I guess I was referencing the statement, Special Master had asked you specifically, is there any reason to believe that, I'm paraphrasing, that there was any agritourism going on, or that they did anything to refute the fact that there are groves, cattle, and all of that? You have no knowledge to the fact of whether or not they do have that on their land?
I don't,
Objection confusing.
Yeah, it was confusing to me too, I apologize.
I mean, I take it for what I get from it, but it's fine. I mean, I would rephrase it. I think I know what you're getting at. I mean, did you hear my questions? Do you remember my questions to you about Exhibit E? And I think your testimony before was that you haven't been allowed on the property to verify whether or not the things that I read to you about the farm activities.
I do remember the bona fide farm question, and
Yeah.
I think my response was that we haven't been provided any documentation proving that it's a bona fide farm.
And I thought you said that you haven't been able to verify.
Well, I also
it.
haven't
Yeah.
been able to verify anything that's on the property because I've been denied. So the only thing I've been able to see is.
And what he's asking you is, are you aware of anything that would contradict that? What I read to you?
From Exhibit E?
Yeah.
I'm not aware of anything.
Okay.
In any of your research, did you see any true agricultural activities going on?
Certainly, I've even stated so.
Would that be considered evidence to show that those things are going on that property?
I can make that determination legally.
Okay. All right, no further questions.
All right. Are there other witnesses the county wishes to present? Or is there any redirect? I mean,
As you have an expert witness, and if she wants to add
Yes,
anything
do.
to.
Do you have redirect first? No?
No, I'm good at this point.
okay.
Do you have questions for me, or what would you?
Ms. Katu, could you put on the record who you are
Thank
and what
you.
your position is?
Looking at a laptop in my face. Joanna Katu, I am the Land Development Director.
And what is your role at Citrus County?
In my role at the Citrus County, I interpret the Land Development Code and the Comprehensive Plan. I'm also the Deputy Growth Management Director, which is
Bless you,
Building,
bless you.
Division, and Code Compliance.
And are you familiar with 10777 East Gobbler?
Yes.
Laurel City?
Yes, I've not been to the site. I'm, like everyone, I'm not permitted access to that, so.
Okay. And what is it zoned?
CL.
And what
with
does CL mean?
Low-intensity coastal and lakes with a mobile home could be allowed there.
And have you reviewed the records for this property?
Absolutely.
And is there currently a residence or home on this property?
Yes, there is a residence on this particular property.
Okay. And in this land use district, is camping or glamping, depending on which term you use, permitted?
No,
Is it permitted by right or by conditional use?
neither.
And are events such as festivals and things that have been shown in evidence up to this point permitted on this property?
No.
If they wanted to hold, if the owners wanted to hold an event of some sort, is there a permit they could apply for?
Yes, the Land Development Code has a provision for temporary permits, yes,
Okay.
for events, festivals, et cetera.
So this would be a special events permit?
Correct.
Okay. Has, in your review of the record for this address, was a special event ever applied for since the case began, the beginning October of 2023?
I can even go back further, but no.
Was there ever anything applied for?
There was a right-of-way utilization permit to put signs in the right-of-way for an event. It was applied for in 2023, never, was denied immediately because there was not enough documentation and there were never any subsequent resubmittals.
Okay. If I could have just one moment, Your Honor.
Sure.
Now, I'm going off of a little bit of what Special Master discussed at the beginning. You heard him talk about, are there land use districts that do permit the activities that are currently happening on this property? Are there areas in Citrus County with different zoning that could allow what's happening there?
Yes, they could get there. They would have to do a land use change to something like we talked about coastal lakes commercial. That would be appropriate in this lakes and rivers area. That would be with a PUD that would open up the public hearing process where neighbors could have some input and we could put some conditions on there for these types of events.
No further questions.
I have a few before we begin to cross.
Okay.
You mentioned I think I heard two different names. It might be for the same thing. Special event permit and temporary permit. Is that the same thing?
Yes, it's under temporary permit section, but it's special events, correct?
And what kind of event, and I could look it up, but to the best of your memory, what kind of event requires that kind of a permit?
For example, the Strawberry Festival, or the Homosassa Seafood Festival, those kind of things. Occasionally, people do haunted houses at their residence, and that would qualify as well.
I have 2 kids. I don't need a permit. It just happens.
Yeah,
It's a haunted house.
these are people where people come in and make money. So
Yeah. My second question is, you brought up a residence. What information do you have about there being a residence? Do you know, is it a 1-story, 3-bedroom? Do you know?
we have the property appraiser. We know that there's a residence there. The pictures show it as a 1-story. I don't usually see the stories too much in the PA, but there is a 1-story. And the adjacent lot that they've talked about got a new mobile home last year. So each one of those do have a residence in place.
The adjacent lot, does it have the same owner?
Yes.
Okay. And is the residence on this property that we're talking about a homestead?
Oh, I did not check that. I don't know.
Okay, just
Yeah.
curious. That's all I had.
Just for edification, when you talked about the land use change and that's a route that could go, what's the amount of time that would take?
With public hearings, usually 4 to 6 months is realistic from submittal.
Would a land use to that, would that still allow for agricultural usage?
Yeah, I mean, as a master plan, you would want to roll anything you want to do in there to cover, so that we wouldn't have to try to mince, is this ag, is this not? You would want to put your uses in there and take care of all of it.
Absolutely. No other questions?
All right, thank you. Any redirect?
No.
Thank you, Ms. Katu. Who is the county's next witness?
That's all the witnesses that I have right now.
Okay. Mr. Alonso, it's on to you.
First time doing this, do I have an opening statement or should I bring a witness
No, so
up?
you have different options. I mean, I'm not gonna, I can't.
Yeah.
But you can make
Preference.
motions, you can start presenting, you can make an opening if you wish.
Okay. I will start with just a brief opening of, I believe what I had said earlier is still intact. I don't believe there's a substantial dispute amongst the evidence permitted or the facts of the case. I think it is just a general understanding of how this state statute will apply, which again, going to how you determine the statement of which allows members of the general public for recreational, entertainment, educational purposes to view or enjoy activities including farming, ranching, historical, cultural, civic, ceremonial, training, and exhibition, or harvest your own activities. Even in the evidence that was presented, there were statements of farm to table. That's a main part of this, is there is an actual going out and grabbing things. So I believe that while I know there are steps that can be taken to make this cleaner, I would argue that at this point, my client has, even under the evidence presented, always been within the definition of the Florida Statute of Agritourism, because that is their core competency and everything else is ancillary to it. However, that still goes to culture. I understand yoga is not picking, fruit. However, it is a cultural activity that can be something that is defined specifically within the statute of what the Florida's.
What is permaculture?
Please.
I don't, so I guess I'm curious.
I will defer to my client.
Hello. So permaculture, light agri.
Yeah, we have to be sworn,
Yes.
names on the record, please.
Okay.
Everybody got excited.
Sorry, I thought y'all were sworn in already.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am.
Thank you.
And can you put your name on the record, please?
Yes, my name is Tara Hubbard.
All right, welcome, good afternoon.
Say owner,
Yes.
your standing.
Technically partner of 1077 Hubs Ranch and Grove. My
And so I
father is
guess
the owner.
what I was curious about is I did see in several of the documents or the exhibits, the word permaculture. What is that?
So permaculture, like agritourism, is a malapropism? No, portmanteau, when the two words are combined to make
Yeah.
something new. So it's technically defined as permanent agriculture, originally created to kind of come back to nature and find ways to farm and steward land in sync with nature. But then the inventors that are from Australia used it to design all sorts of life design, from social permaculture design to architectural design, and it's all kind of going back to nature.
But it's your understanding that regardless of the context, when I see the word permaculture, it's your testimony that I should read agriculture as one of the words that it's composed of.
Yes.
Like when I see culture, it's referring to agriculture.
Yes, permanent agriculture.
Okay.
And typically, permaculture, when people hear that word and talk about it, it is agriculture, but there's much to it. Yes.
Okay. That was just a preliminary question I had. I appreciate that.
Thank you.
I've heard your opening, Mr. Alonso. Do you want to have witness testimony, or?
I would like to bring some, I'd like to call Tara back to the stand just to clarify a few things that were questions that could not be answered based off
Okay.
of prior things. So,
Yes, making myself available for questions, but I also.
so I'm going to ask you some questions.
Okay, perfect. Thank you,
So-
prompting.
And if you could, I know it's going to be difficult. It's
We'll-
the exercise of working that
Yeah.
mic back and forth, but that I'd appreciate that.
Absolutely. First question, what is your role at 1077 Gobbler? Did I forget a 7 there? 10777 Gobbler.
My role is manager. My dad is the landowner, and we have worked in partnership since 2017, creating what is known as Wonderfield Farm.
Okay.
And what type of activities does Wonderfield Farm offer?
So primarily, we are a farm that originally the land was known as the Baines Grove, and our family purchased it from that family a few years ago, and we've done everything we can to restore and regenerate the orange groves that are on site, which are an amazing historical and cultural element of the property. And we have since added, as you saw in the Exhibit E earlier, the cow-to-calf operation. And technically, these practices aren't considered bona fide agriculture by Citrus County, but we do a lot of innovative practices like agroforestry. We have gardens on site to grow food and to have demonstration sites for people. We also, the focus is the farm, but a beautiful thing that we've discovered within agritourism is the ability to bring people in and invite them to stay overnight and go to events. And that's been a huge advantage for us to generate more revenue for the site. So primarily the activities are farming and
It's nice
tourism.
that you want people on your property. I don't want people in my house or on my lawn. So that's noble, but yeah.
And to clarify, you mentioned that there are some activities that are bona fide agriculture. Can you specify which ones are and are not that you guys are participating in?
So according to Citrus County, it is the cow-to-calf operation that is the bona fide agriculture activity on site.
And when you bring people to the farm to participate in a stay, what are the agricultural type of activities they will participate in?
So for the overnight guest, we provide a lot of prompts and an opportunity to explore the land and also to interact with the agriculture. Specifically, the cows are a huge hit, and then we also have goats and rabbits and chickens, which people love to interact with. Our gardens are open, so the same thing, agroforestry, they're all open spaces. The animals we ask only to interact with a fence in between, but the garden areas they can walk through. All of our guests on site are prompted to engage in U-Pick, so we allow the guests to go out and harvest their own oranges and different products that are on site. And then we have regular programming in-house. We do in season, which is October through May. We do weekly yoga on site. We do tours. We have farm days. We have volunteer days. Those are all open to our guests to interact with, as well as people coming in. And same thing with the events. That was just the overnight. For the events, generally the context, so I'm also a conservationist at heart, and I'm a nature lover, and I believe in a concept called neuroconservation, where the more people interact with natural spaces, the more they'll be motivated to preserve and protect them. So yes, some of our events are kind of tricks to get people out to nature, and then they're there and they get to experience what we have and connect with their food source. So sometimes the events aren't very blatantly, this is a farm activity, but we always do our best to weave those opportunities in for people to connect with our farm, with food source. I mean, Florida historically being so heavy in the citrus industry, it's been incredible for me to see people come to our site, see an orange tree and pick an orange from the tree for the first time in their life. Some people, they have these memories of an orange tree at their bus stop growing up, and those trees aren't there anymore. So we're very passionate about preserving those for the public to experience.
When we saw a couple of events that were put up there that were more, let's call it a rave, like
Folksy.
Yeah, folksy, great word. Would you say that is a substantial amount of what your events look like?
No, and I will say the Wonderfest, obviously, I can say was a huge mistake. Very difficult that happened the way it did, and the music was excessive. And I was in a tough place between being a good neighbor and being a good partner for this event. And the music, we said we'll never do that again. We had another event March of this year, and it was a friend of mine, and told him how much trouble we had with our neighbors about the music, no loud music. And they had music, and again, it was just such a, what is happening? So moving forward, to gain confidence, to give confidence to our neighbors and be a good neighbor, I have a amendment in our contract with any events that we have with a decibel level. I know our parcel is unique because we are in a residential area, but we are a bona fide farm. According to Citrus County, I believe this decibel level for a farm is 65 decibels, but residential is 55. So just to be on the safe side moving forward, and nothing over 55 decibels. If it happens,
no.
We get...
Not this guy again. I'm just kidding.
Water Authority.
Okay.
If it's over 55, I would just pull the plug moving forward because I don't want to have any of that. So no, the majority of our events are very nature focused. People are there enjoying the farm, enjoying nature. Sometimes we'll have some acoustic music, a guitar, and it's much more, it's not a rave.
When you're having events like this, what steps do you take to ensure that there are places to use the restroom, and where would people use the restroom around a circumstance like that?
So for events that we know are going to be larger, we do rent porta potties to make sure that there's ample spaces for people to use the restroom.
And then what other types of housing or septic options are there for you?
So again, the unique nature of the property, this agriculture parcel is just about 30 acres, but we own 5 homes that are in single family lots adjacent to the property that people can stay in and use those restrooms. Then the main home, which is the farmhouse next to the barn, has 2 restrooms, which are able to be used. And then we also just built a home on a neighboring parcel with a an outside, someone can actually use that restroom, not just the person who's staying there. So we do have quite a few options for restrooms outside of the porta potty rentals.
Which of the types of things we've discussed between overnight stays, people coming in for short, people coming in for long, or just any other type of events, what's the one that really, what's the primary amount, or what's the, excuse me, let me rephrase. Which one do you see more often?
As far as the events?
As far as events or overnight, which is more common?
Probably the overnight stays. The events are definitely more rare, and we are a regenerative farm. We care a lot about the impact on our land. We acknowledge that we are bordering a nature preserve and seek to just emulate and expand on that. So our larger events, we limit to 3 a year, and larger, in my opinion, has been 50 people or over. Anything, I mean, we could be doing, I mean, I don't know if we could, but I would like to do smaller events more regularly, mostly for the impact of our land and making sure that people feel that it's respected.
And can you speak to an event you have coming up? We had previously discussed that regards somebody getting a certification and what that will entail.
Yes, so October, I believe it's 17th or 18th through November 1st, we are hosting a permaculture design course. There's the permaculture word again, but it is an accredited course with multiple educators in Florida where they're going to come on site and learn and immerse themselves in learning using our space as a demonstration and adding to that for 2 weeks.
Just 1 second. And what's the size of that event going to be?
The course is only going to be, right now, last time I talked to them, they only had a couple signups. So hoping that I think they're going to cap it at 10 people. So it's going to be much more of an intimate event.
Okay. I do not have any further questions, so if you want to ask Special Master.
I have some questions before we get to cross. So you mentioned the forest. We see an aerial here. I thought you mentioned a forest. What would you classify as the forest on the property?
So our wild area is the 40-acre parcel that joins this, but that's not this.
That is not on this photo?
No.
What direction is it?
Oh, are you talking about the food forest?
I want to know both.
Yes,
Yeah.
okay. The food forest is
I'm
right
sorry,
on
wait,
the...
is
I
there
don't know,
an-
do you want him to pull up the map? It's at the very
No,
end.
I've got actually with me, so I'm
okay.
curious as to both.
Okay,
Yeah.
the food forest is in the bottom right corner, kind of the more lush area adjacent to the canal. That's our food forest area, and it really is. The property used to be a monoculture orange grove. When we came to the property, it had basically been rewilded, left by the previous owners for just under 2 decades, and it was an incredible opportunity for us. Again, the permaculture, permanent agriculture, replicating nature. We got to see, in our state currently, the citrus industry has been wrecked by disease. When we came to the property, we were able to see the healthy citrus bordered the property. We're under oaks and we're adjacent to the canal. So we really dedicated ourselves to regenerating those areas, specifically seeing that they were where the healthy citrus was. We've planted over 300 more citrus to regenerate those old orange groves, and then a bunch of various different species to replicate a food forest, which is an agriculture practice that tries to mimic what would happen naturally in a forest, which is why those citrus are healthy, in my opinion, in the University of Florida Institute of Food and Agriculture Science.
Okay. The reason I'm asking, is this in evidence on the other case, the map?
It is in
Yes.
evidence. In
Okay.
evidence.
Would there be any objection to admitting it in this case as an exhibit as well?
I believe that was the one we had like 7 copies of at the end of.
On the,
C?
Was that this one or the other?
I thought it was in the other case that this was admitted.
I have an additional copy if you need.
Right,
No,
which
I'm
case was
just
it
curious.
admitted in?
I
It was
think we
admitted
admitted
in-
in
it was a-
both.
Okay, then let me just,
It was the larger.
let me just ask you about it, then, Ms. Hubbard. So what, it looks to me like what's on this photo is that bottom right portion.
Yes.
Is that correct?
Yes.
All right, and so the food forest, where on this map is the food forest you're talking about?
Where it says Grove on the
Got it.
bottom.
That's what I thought, all right.
Yes.
And the wild grove, what is in the wild grove?
That is, in permaculture, we talk in zones. So zone 1 is the area that's closest to a house. Zone 2 would be this agroforestry area, the bottom grove. That wild grove would be zone 3, zone 4, which is really basically unmanaged. We don't do any intentional management to that area.
What's in it?
Orange groves.
Okay, and the cows, are there cows on the property?
Yes.
How many?
Currently 8.
We had 22 last year. We liquidated the stock to 1, and now we're back up to 9.
Okay, and that is testimony from Mr. Hubbard?
Yeah.
Correct?
Getting sworn in.
Yeah, if you would, sir, thank you.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Mark F. Hubbard, owner and operator of Hubbs Ranch and Grove.
And what you just testified to, you'd also swear to under oath, correct?
Yes, sir.
All right, I appreciate it. I see, and so you have something characterized as wildlife. Is that also unmanaged property?
Yes, that would be zone 5. That is even more, less managed.
Less managed than the unmanaged?
Yes.
That sounds interesting. And when people come onto the property for Wonderfest or any event, do people have unrestricted use of the entire property I see on this map, or are they only restricted to a certain area?
No, for the upper parcel, which we call the North 40, it's kind of the unmanaged 40 acres. We have walking trails, but there is a gate in between. So we don't.
Restricted to this area.
For the events, yes, this is the main event area in the bottom right parcel, which is where the barn is and the
Well, my question
pastures.
is, were people at Wonderfest able to traverse the entirety of the property, or were they caged? You know, were they limited to just one area?
For larger events, we close the gates for the North 40. For our normal events and for overnight guests, this 30-acre parcel is open, but they're not caged.
So, were guests at Wonderfest able to see the cows?
Yes,
Were they able to touch the cows?
with a fence in between them. Yes,
Were they able to have access to the chickens?
yes,
Were they able to have access to the garden?
yes.
What about, were they able to use the canal dock?
Yes.
Okay. Now, on Exhibit E, there have been representations that there's a different legal description, or, you know, besides the address, that the description describes another property. Is that the unmanaged property or something that's depicted on this map?
Yes, the North 40, we went to a pre-app meeting in 2020 to discuss creating a campground. That project did not happen because we are primarily a regenerative farm. As I mentioned before, we see the nature preserve as something we like to emulate. Low impact is something that we feel passionate about. What the county, because that area is not agritourism, and what the county, when we met with them in 2020, was wanting was 80,000-pound roads, full septic, and we wanted something much more low impact, so we abandoned that project, which is completely separate. And I do have plans for, I didn't print them out, but if that's something you would want to see.
I guess my issue with that is just that you have a guest map. I mean, what's the purpose of the guest map?
I guess to show what is there, and this is the 66 acres that comprises our whole project, but the agritourism does not, this North 40 parcel is not our farm.
Okay.
Well, it is. Main approach. The North 40 is a pasture for the cows,
We haven't
There-
got to agritourism.
And there's a fence line between the two, but if people staying the night,
Mr. Norman, if you wouldn't, it's just their time. I don't want to get
I was
distracted.
just pulling the map up
Sorry, I
for
was
you.
trying to pull a map you're looking at.
I don't, I still
I
don't want
apologize.
to, yeah,
Tracking.
if you could, go ahead.
if they stay the night and they want to walk, there's a trail that goes through that property, and that's what that little brown dotted line is. That's a walking trail. And that's merely the only thing that property is used for as far as anyone who's invited to stay on the property. People that are staying in the Airbnbs, they can go bird watch, they can go enjoy that part of the nature. But that property is 99.9% is only used for pasture for the cows.
Okay. Thank you. Let me look at what other questions I have. Were there renta or porta potties at Wonderfest?
Yes.
Okay. And did you seek a special event permit for Wonderfest?
Yes, I was shocked to hear that it was denied today because my partner for that event had provided me, through her research and calls to the county, had said that the person who advised her said all you need is the right-of-way utilization permit, and that she received it. And I believe I have a copy of that. I tried to look on my digital drive but couldn't find it today. But I was shocked to hear that because we did seek it, and I thought that we were in compliance.
I guess this case has been pending for a long time, and I'm just curious, but why would you have 90 days of bookings not knowing what was going to happen at today's hearing? I have no idea what I'm going to do, by the way. I'm just curious.
I'm a victim of hope.
Oh, man, aren't we all? I mean, I get it. I get it. I'm not criticizing. I was just curious. I think, let me see, that might be it for my questions. That's it.
Just a few. You indicated overnight stays are a more common or main portion of your use of this property. Could you explain to me what an overnight stay is for somebody who's staying on your property?
Yes. And when I said that, it was in reference to the overnight stays versus the events. The overnight stay, they book online. I have primarily utilized Airbnb to aggregate for marketing. We also do direct booking since COVID, we were shut down from Airbnb, which was eye-opening. So I've tried to also get some direct bookings. And they're prompted to, when they book, they are prompted with messaging about check-in, and they arrive to the property. They get this map sent to them, as well as a list of our property rules, guidelines, a scope on who we are, what we do. In each accommodation, there's a booklet with our history, more about the land, again, the map. We tried our best to provide the rules, especially under agritourism. And, we do open ourselves to people coming in and experiencing it. But we try to make sure that everyone's educated on the rules and how to interact with our livestock and our farm. And usually a stay is 1-2 nights is our most common. Sometimes people will stay longer. We have a lot of guests who come to visit family in the area. The Withlacoochee Trail also attracts a lot of visitors. And we've done our best to frame the overnight lodging as an experience on site, so people can stay and actually be involved in the farm. We have guests who asked to volunteer with us, which is really nice. They are able to directly buy produce, eggs, vegetables from us, and we try to make an experience.
All right, I think you got a little bit off. I was trying to ask, where do they stay? Like, explain to me.
Oh,
where
I got
they-
excited.
I was trying really hard not to interrupt
Aw.
you.
90% are in the Airbnb houses that are adjacent
I'm
to
sorry,
property.
you can't tell her what to. I'm so sorry.
Well, no. I actually disagree. Mr. Hubbard, what did you have to say?
But about 90% of the over any stays are in the Airbnb houses that border the property. and then they can come in to the property through a gate in the back, and they walk into the property. They park in their property, and they can come and look at the cows, the goats, the rabbits, and we give them a complimentary thing of eggs in their room, and along with a book educating them on agritourism and the permaculture movement. It's not open to the general public. That's one of the reasons why all these folks were denied, because the gates were closed, locked, do not come on the property. They only come on the property if they're invited to a specific small event or event, or they're staying in one of these houses.
I'll let you continue.
Okay. So, I'm sorry, now I'm confused. Do people stay on the property that we're talking about, 10777 East Gobbler?
Yes, there
Okay.
is the glamping village is that portion. But
Okay.
like my dad was saying, Mark, the majority of our reservations are in the houses.
Okay.
I would love to have more glamping, but they're not as popular right now.
Okay, and
Excuse me, there is one house on 107, there's
So,
two
Mr.
houses on
Hubbard,
107.
I will go with Ms. Harrison on this one. If you all if you hear something from your daughter that you disagree with or want to supplement, Mr. Lonzo will be able to bring you up
Yes, sir.
and call you.
I apologize.
It's just, no, it's fine. But we just want to hear what she has to say at this point.
and
Yes.
he took the words out of my mouth, actually.
Yeah.
Do you also rent out the main house
Yes.
that's on the piece of property?
Yes.
Okay. So, it looked from some of the photos that we have seen, some of the bigger events, and I don't know if it was Wonderfest or Sacred City or one of the other events, that there's additional camping available for your overnights. Where did those people stay when, like the pop your own tent people
Yes.
or those individuals?
We primarily dedicate one of the pastures to the camping.
Okay.
So there's 3 pastures, and we'll come in before, clean out the cow poop, and let them set up camp in those spaces.
Okay, and since you clean out the cow poop, I'm assuming you clean out the cows too.
Yes,
And you
we
move them somewhere else?
Yeah, we move them to, usually our biggest pasture is we call it pasture 1. We'll move all of the livestock, the chickens, the goats, the cows there to be safe and contained for the event.
And when you do have the additional camping on site with the additional people, where did they use the facilities at?
The facilities.
Like bathrooms? I'm trying to be.
Yes. Yes. Okay. We bring in porta potties for larger events, like I mentioned before. We also have a restroom at the farmhouse
Okay.
that can be accessed, but for the larger events, primarily the porta potties that we bring in.
Okay. So I'm going to assume, which is never a good thing, that the tents and such are not booked through Airbnb. They are? So when you pop your own tent?
Oh no.
Oh, okay.
I thought you were talking about the glamping.
Okay,
Sorry.
just the glamping. When I'm thinking tents, I'll talk
Yes.
about pop your own tents. If
Yes.
I'm thinking glamping, I'll say glamping, okay?
Okay. Thank you.
So for the pop your own tents people, I'm assuming they don't book through Airbnb. So
No.
how is that done?
So that is done when the event is happening. People who want to come and join and be a part of the event, if they want to stay the night, not have to book a hotel somewhere or leave, we allow them to pop their tent in one of the pastures
Okay.
with a ticket. I mean, they would buy a ticket to the event, and then they would have that access.
Okay. For the Sacred City event at the beginning of the year, did you guys put that on, or is that a rental?
It was a partnership, yes.
Okay.
It wasn't our event.
What does that mean by partnership?
So Wonderfest was kind of a partnership. So most of my clients right now, unfortunately, are my friends. I would love to have more outside people, but right now, like the Sacred City was a friend of mine who he has a group that gather in the St. Pete area, and they wanted a larger space to gather. So technically, he organized the event, and I was a partner. The land was a partner.
Did you apply for a temporary permit for that event, Sacred City, at the beginning of the year?
No.
Why
I
not?
I believe the client did. They got their own insurance, and I believe, got a temporary permit.
Did they provide you proof or a copy of the temporary permit?
I believe they submitted I don't know.
Okay. That's a very, thank you. Very rarely do witnesses remember that I don't know is an okay answer, so thank you. Can you explain to me what a calf to cow? Because usually it's, or cow to calf is, because I thought it was calf to cow.
Yeah, I am confused by that too. Can I
Okay.
have my father answer
Okay.
that?
Yes.
Okay.
That's when you have adult female cows
Mhm.
and you impregnate them
Mhm.
and they have calves.
Okay.
And then you raise that calf up to either be sold or you raise it up and they have calves and you build up your herd to a certain number and to the property it can handle and then you liquidate it. And
Okay.
you do that, they do that every year. So it's just, that's what a cow to calf operation is.
Okay. And Mr. Hubbard, while you're up here, I think you said you're the actual owner of the property. Do you live there?
I do live there, and I am the owner and the DBA of Wonderfield, and Tara operates the Wonderfield business as a layer over the Hubs Ranch and Grove
Okay.
business,
So
or
since you-
land ownership.
Since you live there, where do you live since the main house is rented out, as are the tents?
In that new mobile that's there, I'm there 3 days a week, and I go to St. Pete 3 days a week.
Okay.
And sometimes I'm here 4 days a week, sometimes I'm there 4 days a week. You know, it depends on what, how many lawns need to be mowed and trees need to be cut and
Okay.
cows need to be moved.
So you're a Florida snowbird, up here in the north some of the week, down in St. Pete some of the week. Okay.
And then my new wife has a house in Orlando,
Okay.
right in Kissimmee.
Okay.
So it's a triangle.
It's a triangle. Okay. Let's see. All right, I think that concludes all my questions.
Any redirect? Yeah.
Do you advertise yourself as agritourism?
I do my best, yes.
You mentioned that you use Airbnb frequently. Do you place on Airbnb identifiers that if they book for a glamping, they will be participating in agritourism?
Yes.
On the property, when people enter your property, is there anything that identifies you as an agritourism site?
Yes. Per the state statute, we display agritourism warning signs throughout the property to let anyone who comes on site know that they are participating in agritourism activity by being on our farm.
And then the last question, to use the term that was coined, do you allow pop your tent stays at any time other than an event?
No.
That's all I have.
Do you have any other witnesses?
Do not.
Okay. In that case, I welcome closing statements from each side if you wish.
Yes.
Okay.
Okay. So this case turns on the use of the property. The county's position is that the sleeping / glamping, camping, overnight stay use is not one that is permitted in the coastal lakes area the way as this property is currently zoned. Under 2401, which outlines everything that is permitted by right or otherwise on the property by conditional use, camping of this sort is not one of those permitted uses. The argument from the respondent has been that it is agritourism. If you look at the Attorney General opinion in conjunction with the statute for agritourism, agritourism is defined with 570.86, where additional camping, glamping is not something that is listed as an activity for the use of this property. Additionally, the Attorney General opinion makes it clear that it is the county's job to determine what is an agritourism activity. There is, to my knowledge, I could not find it, any additional case law to help assist to further define this term. From the statements made by the Hubbards, I'm sorry, I was trying to figure out how to say that without them sounding married. The Hubbards, as well as the evidence in record and testimony from the code officer as well as Ms. Katu. There is a path for these individuals to be able to get to do everything they want on their property in a healthy way that does not violate the code and would allow them to continue to use their property in a way that lets them have the events that they want. Unfortunately, the events that they're holding and the uses that they're doing of this property exceed, in the county's position, exceed what is permitted in the agritourism activity exemption that is outlined in 570.85. So for purposes of this, the general public is sometimes allowed on this property. As testimony stated, they can't just have access to the property. Additionally, if you look at the activities listed in 570.86, these are activities that are specifically geared towards and around utilizing the agricultural activity to help inform and educate and have been an experience for the general public. The events, festivals, whatever term you want to use, that they're using this facility for do not fall under that. They're outside of the scope. If you're, for lack of a better term, holding a rave, even if you only do it once, the rave is not an agritourism activity. Additionally, under agritourism, we're supposed to take into account the activity, the impact these activities have off-site. This case came in based off of testimony due to a complaint from a neighbor due to the sound and the noise and the impact their activities were having off-site. As Special Master stated previously, you could argue 95% of their activities may fall under agritourism, but 5% don't. And that 5% falls under the sleeping, glamping, camping for additional lodging, as well as these events. So at this time, the county does believe, with the evidence presented and testimony from both sides, that these events are outside of agritourism. They fall outside of the definitions. That means that they would fall outside of the 570.85, where they do have, that outlines what the agricultural exemption for agritourism is, where they meet the first prong. We have the property appraiser's website. That's what the property appraiser says they are, bona fide agricultural property. They don't meet the second prong. They're not actually doing an agritourism activity on the property. And that's the aspect where they fall short in being able to continue doing these activities on the property. They need to apply to the county for the use permit so that they can do activities that are permitted on that zoned lot legally, as well as safely for the for the public. The additional statements as to signage, as well as whether or not they advertise as agritourism, I understand why they feel that's important for them. However, it deals with liability. When you look at the statute, it has nothing to do with whether it qualifies for agritourism. You can call something anything you want it to be. We have the definition that we're working with, as well as the county having to be the one to determine what qualifies as the agritourism activity. And we do not believe either of these uses qualify as uses under the definition or the way the statute is drafted or intended to be utilized.
Is that it?
Yes.
I have some questions before we go to Mr. I'm sorry. I mean,
This is awesome.
why is this awesome?
Because I'm a nerd and I like legal theory.
Okay.
I don't know.
Well, I don't get out much, and it's going to show in some of these questions. But on the first question I have is I want to drill down on the county's case a little bit about this. I'm not holding the proof and saying it's 95.5. I'm not saying that. But I do think that there is evidence, even from the county, that there is some agritourism happening. I feel like Mr. Norman testified to that.
He did.
So I don't really care about the number, but what I'm interested in is, from the county's perspective, let's say it is 95.5, and there are activities that are definitely not agritourism that are happening, like definitely not. Wouldn't the remedy be to, because they're all gone, no one's testifying as of today that there is an agritourism property or a non-agritourism thing happening. There's evidence that they have happened, and perhaps that they will again. But the remedy, from my perspective, if that was the case, would be to admonish them not to do it again, or to put a factual finding that it did happen without a penalty. Does that make, I mean, would that be your understanding?
So
If that's the way I went.
we have, I believe, testimony and evidence before Your Honor that the events are still ongoing.
Right.
The use is still, especially for the camping, glamping, is still ongoing. In fact, I didn't hear anybody testify today that there's not somebody currently out at one of these tents.
There's no evidence of that.
So there could be somebody out of a tent right now. So that one could be ongoing.
There is no evidence of that before me.
We had the,
There's reservations.
The
I do
reservations
have
up,
evidence
right.
that there's
There's
reservations,
reservations.
over the next 90 days.
and that also there are events over the next 90 days.
I know, but there's no evidence that there is a violation as we sit here today. There's evidence there were violations. There's evidence that there may be violations in the future. And by the way, I'm not trying to force you to change your, I'm telling you what I'm thinking. So I honestly have no idea what I'm going to do right now. And you know what that means.
I really don't like that answer.
I know,
I do know,
I know.
what that means. I really don't.
And
I don't
I
like
apologize
that
to
answer.
you. I apologize to Miss Antrim. I apologize to you.
Because he doesn't know what's
He
coming.
doesn't know. But, and I honestly, I would apologize to his clients. What that means, Mr. Alonso, is there are occasionally difficult questions that come before me that I don't know the answers to, believe it or not. And what I usually do in those situations is I reserve ruling, and I may ask for briefing. I may ask you to answer the questions on my mind that help me come to what I believe is the right answer. I don't know if I'm going to do that yet. But what I'm interested in your response to that question.
At this point, because they're still taking reservations, they're still taking and organizing events. The events are still ongoing.
Okay.
So the county's position is that the violation is continuing to be ongoing. If they came in here and said, we canceled all events, we canceled everything, we don't have any bookings coming, then yes, they stopped the activity, the use.
Okay.
That's not the testimony before Your Honor today, so I don't believe that
It is
that
a
would
basis for
apply here.
injunctive relief if there's an ongoing nuisance or evidence of future activity. My second question is, if, let's say for a second that it is all agritourism, just arguendo, does that override any requirements to get special event permits?
If you find that every single event that has happened out there and that the glamping is all considered agritourism, it would. Because if it's considered agritourism under 570.85, it would exempt them from local ordinances, regulations, rules, or policies that would prohibit, restrict, regulate, or otherwise limit agritourism activities, which is why that it turns on that definition.
Okay. Is there anything else? I don't know if
Just with regards to off-site impact, I mean, I know I mentioned it earlier.
Yeah, what is, I guess I don't understand that point.
So if in the next sentence under .85, it says, this subsection does not limit the powers and duties of a local government to address substantial off-site impacts of agritourism activities or any emergency as provided under chapter, or in chapter 252.
So how does this code enforcement case do that?
Well, we're dealing with the noise for the use of the property as the event, the lights, I believe, we talked about the green streaming lights that were lighting up the sky in some of the photos.
Yeah.
Additionally, if they are using,
Do you have a
Camp-
do you have a noise ordinance?
I believe we do also have a noise ordinance, which was what Ms. Hubbard was referencing in her, her testimony.
I didn't know you had one. Okay.
Additionally, part of what the camping, glamping, and why we have the code for it is if they are doing anything with like human manure, where you're using human poop, and or people aren't using the facilities, people are out there partying, popping tents, and everything. They're right next to a nature preserve. That will have off-site impacts. Unfortunately, I don't have, you don't have the testimony today in front of you because we haven't had that happen yet. Unfortunately, we would like this to be the case that stops it from getting to the point where we have who knows how many people coming out testing the water quality or anything of that nature.
My final question is, let's say that all of their activities, again, just arguendo to help me understand the points, are agritourism, and then they host a wedding on the property at their event space, and would they be required to get a special event permit for that?
For the ceremony of the wedding, they would not, because under 570.86 specifically outlined is ceremonial, which is the actual ceremony of the wedding. The county's position is if they're going to have a party there afterwards, that would require
So the
a use
reception.
permit. The reception, correct.
Wow. Let me just look at that. They don't pay you guys enough. I mean, that's the truth. Those are good arguments. I'd love to hear your closing statement, if you have one.
I do. I enjoy this, you asked why, because this is legal theory to me. Takes me back to law school and arguing questions that may or may not be decided, and ultimately probably do need briefs and do need further investigation, and I wish we were where other states were at, where they clearly defined what an agritourism activity was. States like Maryland, who define a fall festival, which includes rides, which includes games, which includes food. Those are clearly allowed, and that's part of it, because the driving force of this, if you go to the statute, is we are trying to promote agritourism, and we are trying to create a revenue generator for these folks outside of it to try and preserve it and keep it coming. Nobody in here, including my clients, think that what happened on October 23rd, which was the crux of this, was what agritourism was intended to be. And my clients have taken corrective action, and they're not going to continue doing that, and they're implementing that in all their contracts going forward, including the events that were mentioned that are pre-booked. So the OG's, opinion, I read that not as the county gets to decide what agritourism it is. They get to decide whether or not it's an agricultural site or not. And then we can apply agritourism to it. The fact of the matter is, every person that comes out is notified at their booking that they're coming for agritourism. You can't click book this without knowing I'm going to stay in a tent so I can go pick some oranges and play with the cows. To the off-site effects, which does mitigate it, and I agree with that. We don't have any evidence before you of people complaining outside of the one complaint, which is still not on the record.
So hearsay is admissible in an in a hearing like this. It's just not, I can't use hearsay to determine whether an element of the thing occurred. So the only reason I bring it up is because I think there is evidence. I actually don't think that part applies here. I think that would be if they were bringing a noise ordinance violation or something like that.
That was going to be my next point, is the offsite is a noise violation, which we are not accused of. in this instance. You've heard from my clients, the drive of this is trying to create an opportunity for people to come and be in nature and be able to respect it and learn from it. I go to the definition in 570.86. You're right, it does say ceremonial. That's the same statute defines it as recreational or entertainment. It doesn't say you can't have fun while doing agritourism. It is a broad definition, which we would ask the special master to encompass the fact that folks that might want to come out might want to know that they've got a place to stay and experience a little bit of the Grove from a different perspective and not in a house. So I would ask that we still maintain the opportunity to continue using it as we are under this restriction, and also to understand that there are other paths that we will be exploring to try and clean this up and make it less of a question as we go forward, because as I have said many times in the last 5 hours I've been here, we are wanting to work with the county and we want to be able to move forward in a positive relationship. I'll be honest, that to tell you how confusing this all can be, that testimony was the first time I found out how a nice, straightforward, non-questionable way we could do this. So I can attest to you, we're going to walk out of here, and I've written all that down, and I'm going to tell my clients, hey, I don't want to have this fight again on the next event. Let's go do this part. But that's 4 to 6 months. And as my client said, she is a victim of hope. We have bookings. We have people that are coming out. We have a certified class where educators are going to come learn about agriculture, which is not, can't even argue is outside of the scope of this. So I would ask the special master to find that we're still in use, understanding, or we're within the use of what we need to and protected under that statute.
I'm currently the chair of the Judicial Nominating Commission in Orlando. So whenever there's a judicial vacancy, we get applications for people applying to be judge. And one of the applicants, this is a public record, so I can tell you this, on the application wrote that she wrote about an experience that she thought might reflect poorly on her record from long ago. And she said that even someone who's lost can be found. I thought that was probably not appropriate on a judicial application, but I think it's kind of in a vein. I think regular people do have a right to be victims of hope. But here's my question to you, Mr. Alonzo. Let's say, arguendo, that Wonderfest is not agritourism, but everything else is. Just for argument's sake, hypothetically. What do you think the remedy should be if that was the case? If I found that that was not agritourism, what would you want me to do?
I would, and I'll put on the record, before we even went into this hearing, the first thing my client is doing, as long as we're out before it's closed, we'll be walking over to get a special permit and a special zoning permit for this year's Wonderfest, regardless of whether or not you found it was agritourism or not, because I find that that is something that we should be doing. Just to let the county know it's coming.
In your view, is it a violation of the code?
In my view, it is a violation of the code, but the code is preempted in this instance from being able to restrict them from doing an agritourism event.
So it's your position that if it's like a property that predominantly does agritourism, that they can still do non-agritourism activities and it would still be exempt from the LDC?
I think trying to take an event that is predominantly about bringing people onto a live, active farm that allows them to be able to dance under the stars should not restrict the fact that it's for them to be able to come out and experience the agritourism aspect of it. Again, it is a agricultural site, and that is...
Well, this is why I was a little confused, Mr. Alonzo, with some of the arguments, because to me, I feel like Exhibit E really helps you. I feel like Exhibit E is a huge help for you, but you've wanted to disavow it for the purpose of this property, and I don't understand why. Doesn't this help you? Doesn't Exhibit E help you?
Now that I've seen how it is used.
Well, no, I mean, I'm curious. I don't want to, how does it hurt you?
I think the evidence was trying to be used to state that my clients were made aware of what they should have done and never did. And ultimately, the argument that was made at that time was, as was testified by my client, had nothing to do with them getting agritourism up and going. It had to do with, can we set up a camping site that is not on an agricultural parcel so we can encourage the agritourism, have people stay there? And they were told, yeah, as long as you, for lack of a better term, tear down all the nature and have a massive impact. So from my perspective, I'm not opposed to Exhibit E being in. I oppose the idea that those are all one parcel and that what they were told about that North 40 is exactly what would happen.
Well, you did oppose it being in. No, so I guess that's what I'm trying to understand, is I don't understand why. I guess I understand. I agree that's probably part of the intent, and I honestly, I take it probably for that, but I don't know how relevant that is. I mean, your challenge here is whether there's exempt activity or not, and there's a huge amount of information on that document that goes toward the idea that it is nothing but a farm.
I will also, slap on my wrist and, future thing.
I'm only arguing for the sake of learning.
I had just received that moment and actually hadn't even gotten to the second page of the statements where they were talking about what their intent is to do. I do agree that that is something that is admissible under, or favorable, because it outlines what they do. It really gives a definition. I don't think it's necessary because we have plenty of testimony and opportunity to see that we are doing bona fide agricultural events with our tourists, and that is squarely under that definition. But I do contest the fact that what should be done under that North 40, and this is how you get in compliance, is different than what you need to do if you're in compliance with a different parcel, which is why I was making that argument.
All right, I understand. Is there anything else either side wants to tell me before I tell you what I'm going to do?
I appreciate you taking the time to do this. Yeah.
I am not going to rule right now, and I'm sorry. I think there's three things I'm thinking about, but I don't know that I'll be issuing a briefing order. I feel like I might actually be able to come to a decision on my own based on what you testified to. Now, here's the rub. The rules require me to only announce an order in a public hearing. So I cannot issue the order remotely. Like, if I come to a decision 2 weeks from now, you're not going to get an order from me. I'm going to give it at the next hearing. Okay? You don't have to be here, but, I'm sorry?
Excuse me, but I think you have to continue this hearing to
The next hearing, to be able to make your announcement.
I'm just going to ask to have it on the agenda. I mean, it has to be noticed. So I think what I'm going to do is reserve ruling. I will issue the order on this case. I do want to see it on the next agenda. I plan on issuing. So whether I issue a briefing order or not, if I do, it'll look like something like this. It'll say, please answer this question. Please answer this question. Do it in 5 pages or less, and have it to me 5 days before the hearing. Because I want to be able to, yeah. It doesn't happen that often. I'm sorry. Is there anything else?
Nope.
I want to commend everybody, including the witnesses. I thought y'all did a really fantastic job, and it's not really any consolation to the parties, but it is an interesting issue. So, all right. So the time is 4:03. This hearing is adjourned.
We like to keep you on your toes.
Yeah.